1 to 3 are the jail appeals for the first time it has come up.
This is an appeal from jail. Admit, call for LCS. Registry is directed to appoint an amicus curiae from the empaneled list. MSS Jahan and additional EPP. Assam appears for the state of Assam. So, list the matter after 4 weeks. Same order, item 1, 2, and 3.
Ah.
LCS have come.
LCS are here. Paper book is not ready yet.
Okay.
May I please,
Yes.
Your Lordship?
Yes.
Lordship, I'm appearing on behalf of amicus Aether, Arunakshadhar in this case.
Mm.
Your Honor, he is out of station. Lordship, in this case, we have not received the paper book as of now.
No, we have not
It's not-
directed for preparation also.
not
We'll
prepared
direct for preparation. Heard Mr.
A. Singha on behalf of
A.
Aether.
Singhal, Leonard Counsel appearing on behalf of Mr. A. Dar, Leonard amicus curiae for the appellant. Also heard MSS Jahan, Leonard additional PP Assam for the state respondents. LCS have been received. Registry is directed to prepare the paper book and list the matter after 4 weeks.
Obliged, Your Lordship.
No, A order. 6, same, I think.
No,
LCR is here.
Lordship, in this case, service on respondent number 1 is returned unserved.
Oh, why?
Insufficient address, but address is the same, only in the envelope, father's name is not mentioned.
Hmm.
I shall take first steps, Lordship. And another prayer, he is still, it is an appeal against acquittal. He is still under bail bond. So through trial court, it may also be served.
Okay.
Through trial court or by through the officer in charge of the concerned police station can also do.
That will be better as in consult police station. Heard Mr. Okay. Heard Mr. S.T. Purgayastal and counsel for the appellant. Stop. No, cancel it. Mr. S.T. Purgayastal and counsel for the appellant is permitted to to post fresh notice on the respondent number,
1
on the
is the accused.
respondent number 1 to the officer in charge of which police station?
Kachar.
Such, it is
Silta.
Silchar police station.
Correct.
Paragraph cover, first paragraph.
Also, Lordship.
Will the judgment?
Yes, your
First
judgment is
paragraph
page.
only judgment. Officer, could you understand?
Silchar police station.
To the officer in charge, Silchar police station. Kachar district, is it?
Kachar district.
District of Kachar. Stop. Within a period of? 3 days. Within a period of 1 week from today, stop. LCS has also been received. Accordingly, registry is also directed to prepare the paper. After 4 weeks,
Lordship.
we start.
Obliged.
Jail appeal.
May I please, Your Lordship? Jail appeal, Your Lordship. In this case, Your Lordship,
While judgment dated 30/7/2018, Palpal and Sessions of Jorhat convicted the appellant accused under section 302 for life yellow. In this case, 7 PWC is examined as including a medical and investigating officer, Your Lordship. Your Lordship, on paragraph 4, page 4, Your Lordship, FIR can be. There is the FIR. Because appellant is, this case is the wife and this is the husband. So,
Informed is the husband.
no, yeah, this is the husband.
This is the husband.
This is the husband and wife is the appellant. Accused appellant. Therefore, Your Lordship, and the FIR 13/2017, Your Lordship, it is lodged by O'Neill Bora, is the brother-in-law of the appellant, Your Lordship, and this brother of the deceased. Death of husband as a result of being assaulted by wife. Humble submission is that around 9 p.m. yesterday on 29/9/2017, Kusheshwar Bora, son of Sri Bhupen Bora, a resident of Kundorka, was killed as a result of blow dealt on his head by his wife, Srimati Vandana Bora, with an iron rod. And therefore case is registered, Your Lordship.
He is the brother-in-law of
Brother-in-law of the appellant, Your Lordship.
Brother of the this deceased.
Brother of the deceased and brother-in-law of the appellant.
yes.
Next, Your Lordship. Is 7, Your Lordship. Thus is frame, Your Lordship, one head is 302. They are committed offense punished under section 302 IPC and trial listed, Your Lordship. Page 7 and one head 302. Case also registered under 302 and suspend for 302 IPC. And committed the case here. In 7 PWs examined, Your Lordship, PW1, page 9. O'Neill Bora is the informant and brother of the deceased and brother-in-law of the appellant, Your Lordship. Page 9, I am reading, Your Lordship. O'Neill Bora, sir. I know the accused person. She is my sister-in-law, Nobo. She is wife of my late elder brother, Tukeshwar Bora, the deceased. I reside at the distant place away from the house of my elder brother. On the relevant day at about 8-9 a.m., my nephew Sri Pranjal Bora, and this Pranjal Bora is PW2. Pranjal Bora came to my house and called me to his house. I reached the house of the deceased and found his dead body on the floor near his bed. When I reached, their police persons were present there. Police directed me to go with them for postmortem of the dead body. The body was taken to Jorhat Civil Hospital for postmortem. I noticed injury on the head of the deceased. I could not see other injury as I was nervous. Then I lost FIR before the police. I put my signature in the FIR and FIR was written by one Rupam Bora. That Rupam Bora is examined as PW3. He is a villager. Cross-examined and the prosecution had declared as hostile here. And this PW1 declared hostile. At this stage, the cross-examined, Your Lordship, it is not a fact that I did not state before the police that deceased used to consume liquor and used to commit atrocity on his wife and his children. On 29/27 at around 9 p.m., the wife of the deceased hit my elder brother with an iron rod, to which he fell down on the ground and succumbed to his injuries thereafter. Cross-examination. I do not know the contents of the affair. My nephew resides with my father, separate from his parents' house for last 5 years. That PW Pranjal Bora, PW2, he also not reside with his parents. He stayed separately with grandparents. I do not have any personal knowledge about the incident. It is not a fact that I did not see the injury of the deceased. He is not an eyewitness. He heard from his PW2. He called and then go there and then the dead body has seen him. He has not knowledge about the incident, how had died his brother. And PW2 is 11 year old. It is Pranjal Bora. Pranjal Bora is the son, your lordship, of the deceased and appellant. Age of 15 years, PW2 15 years on Pranjal Bora. Deceased was my father, Ekus is my mother. I reside with my grandparents for last 5 years. He is not staying with parents. On the relevant day, I visited the house of my parents at about 7 a.m. I found my father in dead condition. I asked my mother as to how my father has died, to which she told that she does not know how he died. I noticed injury on his head. After my arrival in the house of my parents, my mother informed that police. The accused, the appellant, she herself informed the police. Police came accordingly along with the executive magistrate and who held inquest about the dead body of the deceased, where I put my signature. Exhibit 2 is the inquest report, exhibit 2 is my signature. At this stage, the witness is declared hostile. Prosecution declared hostile. Cross, it is not a fact that I did not state before the police that last night my mother hit my father with an iron rod, to which he fell on the ground. Thereafter, when I approached to pick him up, my mother obstructed me from doing so by saying that if he wakes, then he would cut us all. Next day at about 6 a.m., when I went to my house, I found my father dead. It is not a fact that I have stated falsely for the sake of the accused, who is my mother. Cross-examination, I cannot say as to how my father died.
It
Yes.
is said, it is not a fact that I did state it.
It is not a fact that I have stated falsely for the sake of accused, who is my mother. And cross-examination on behalf of the accused, I cannot say how my father died, as my father used to quarrel with people after consuming liquor, so I was staying away from my house. I did not state before police as told by learned PP today. My mother did not tell me that she assaulted my father. What the actual why he died, how he received accident, it is also not known. He is not his. Next day he has arrived and he found the dead body of his father. He also staying separately. Except the accused person, nobody in the house here.
But
Only
this cross-examination by prosecution,
prosecution. Nothing you say. I cannot cross-examine on behalf of the accused. I cannot say as to how my father
no,
died.
above that.
Above that. It is not a fact that. Cross-examination. It is not a fact that I did not stated before
Just
police.
Not. I did state it, it says.
I did stated before police that last night my mother hit my father with an iron rod, to which he fell down on the ground thereafter. When I approached to pick up him, my mother obstructed me. My mother obstructed me from doing so by saying that if he wakes, then he would cut us all. Next day, about 6 a.m.,
Just
when
check up the LCR. You just check up the LCR. Which is it is stated or it is not stated?
Check the original.
LCR,
That's all.
can you read? Assamese?
At least.
You could review.
Exhibit. This is PW2, no?
Yeah.
It's PW.
Or
I did state, then
no, in the original. Original. Things
this
or-
is the original. This is a Xerox one.
to any
Now, PW3 is 13 is one Rupam Bora, is the village headman who wrote the FIR, your Lordship. FIR written by PW3 Rupam Bora. Lord. I know the accused person. I am the government village headman and villager. I know the accused person. She is from village, my village. He also knew deceased who happens to be the husband of the accused. Incident took place prior to Durga Puja last year. I was telephoned by police. I was told by police that one person has died and his wife has gone to the police station. Accordingly, I rose to the house of the person who died. Then I found Tukeshwar Bora in dead condition. He was lying on the floor of his room with his head facing the ceiling. I did not find accused at her house at that time. At that time, police also came. The brother of the accused, Sri Onil Bora is PW1, also came and took the dead body for postmortem with the police. One executive magistrate also came to the house of the deceased and held inquest over the dead body of the deceased. Exhibit 2 is the inquest report and Exhibit 2 is my signature. Later on, I wrote the FIR as told by the informant. Exhibit 1 is the FIR and Exhibit 1-2 is my signature. Police also seized one piece of iron rod at seizure list Exhibit 3, when Exhibit 3-1 is my signature. Material Exhibit 1 is the seized iron rod. I noticed injury on the head of the deceased. You also notice one injury on the head of the cross on behalf of the accused. I do not know anything about the incident. I cannot say from which place the rod was seized. I cannot say from which place the rod was seized. He has not seen from which police has found the rod. It is not a fact that I did not state before police that I saw the rod lying near the dead body. It is not a fact that I have deposed falsely today. I cannot say how deceased died. It is not a fact that I did not see any injury on the head of the deceased. He also come laterally hears witness. He also not seen. Subsequently, he has come after call by police. PW4, your lordship, one Moni Gogoi. She also hears witness. I am reading him. He is a villager. I know the accused person. She is my related sister-in-law. Accused person, related sister-in-law. Her deceased husband was my elder brother. She resides near my house. Incident took place on last Durga Puja. At the time of incident, I was at my house. I came to know about the incident on the next day of the incident. Accused told me that Kali Marilu Morile. As per her statement that accused informed her that accused is beat the deceased and he died. She told me that she assaulted her husband. Then she rushed to the police station. I went inside the house of the accused. On arrival of police and other people, I saw the dead body of the deceased husband of accused near the door. Police held inquest over the dead body of the deceased. Exhibit 2 is the inquest report and Exhibit 2-3 is my signature. Prosecution of the accused. Deceased used to consume liquors regularly. He was also in habit of creating nuisance after consuming alcohol. Sometimes I used to hear the quarrel. I cannot say how the deceased died. I did not ask the accused. It is not a fact that I stated before police that accused told me Ali Morile. I did not go through the contents of the Exhibit 2. I signed as told by police. She also shares witness, subsequently come. EW5 is Vipul Bora, one Vipul Bora, is a co-villager. He also hears witness. I know the accused, she is for my place. I know the disease of his case. He was also from my place. Incident took place around 6 months ago. At the time of incident, I was at my house. I saw many people going to the house of accused. I also accompanied them. I saw the dead body of the accused and deceased who was killed. I heard from the police that accused killed her husband. From the police, he heard from police. Exhibit 3 is the seizure list, where Exhibit 3-2 is my signature, by which police seized the rod. Metal Exhibit 1 is the seized rod. In prose, on behalf of the accused, it is not a fact that I did not state before police that I went to the house of accused along with many other persons, that I heard from police that accused was killed her husband. It is not a fact that nobody told me that accused killed her husband. I cannot say from which place police brought the rod. I saw the same at the hands of police. I do not know the contents of the seizure list, Exhibit 3. The contents of the same was not read over to my police. So here is he heard from police. He also not seen the form which police brought this rod. See that rod here. PW6 is the medical officer, Dr. MO, medical officer. Demonstrator, where I am, is a demonstrator, Jorhat Forensic Medical, Jorhat Medical College and Hospital. On 30/9/2017, I was posted at Jorhat Medical College and Hospital as demonstrator, Department of Forensic Medicine. On that day, as per police requisition in connection with so-and-so GDNT, I held autopsy over the dead body of Tukeshwar Bora, Hindu male, aged about 40 years, son of so-and-so, resident of so. The dead body was brought and identified by QB Constable Pramod Chandranath and relative Pranjal Bora. Pranjal Bora is the son, PW2. Is identified. On examination over the dead body of Tukeshwar, I found the following injury. The male dead body of average build, brown complexion, wearing a engine so-and-so, body worn stain, body cold externally and internally, rigor mortis, fully developed all over the body, eyes and mouths closed, so-and-so stomach are healthy. Injuries here. Now the injuries here. Injury 1, abrasion with contusion of size 7 cm so-and-so is present over the left shoulder. Abrasion means damage of skin. Abrasion and contusion injured with blood culprit swelling. Contusion. So left shoulder. Injury number 2, linear abrasion with contusion of size 10 mm so present over the front of neck below the typed cutting. Below the topid cartilage. Topid cartilage is a small organ that produces hormones to control the body. That topid cartilage, it is found one injury. Linear abrasion, the blood is found in swelling also found. Injury 3, linear abrasion with contusion with size 20 cm is present over back of neck, extending up to the left cheek. And injury number 4, lesser of size so and so and is present, 1.5 into 0.5 present, 1 cm apart, soft tissue depth over the left cheek, just above the angle of mandible. Marks of ligature or neck is described. Escape laceral over the parental lesion of size 4 cm, once a soft tissue is above the left mastet with underlying constitution. Membranous fail, brain and spacer for healthy and not examined. Liver, kidneys, bladder fail, and healthy and empty. Well, sleeps cartilage as described healthy, organs and healthy. Now, your lordship, next page 21. More detail described in the injury or disease. Page 21. In my opinion, upon finding of doctor, medical officer, in my opinion, the cause of death was due to hemorrhage and shock following the injuries sustained as described. All the injuries were antemortem and caused by blunt weapon. Approximate time since death is approximately 12 to 24 hours. Just examine. Next. Exhibit 4, the postmortem report where exhibit 4.1 is my signature, cross examination on behalf of the accused. The injury was on the left upper side of the abdomen. The injury was on the left upper side of the abdomen. The injury found in this case cannot be sustained due to falling on the hard substance. But there is difference in the injuries is described that whatever injury, but it is there is no mention is the abdomen. But cross examination doctor said the injury was on the left upper side of the abdomen. But cross doctor said the injury was on the left upper side of the abdomen. There is contradictory. There is contradictory. Always injuries is mentioned 1, 2, 3, 4. There is no mention about the abdomen
Where is
injury.
the post-mortem report?
Page 59. Page 59.
Postmortem report, your lordship.
It starts from page 56.
56. Step from 56. I am reading a page 57, injuries. Bottom, page 57. Position character injuries. Abrasion with contusion of size 17 is present over the left shoulder. Page 58, injury number 2, linear abrasion with contusion of size 10 cm and 2 cm is present over the front neck below the typhoid cartilage. Injury 3, linear abrasion with contusion of size 20 cm into 40 cm is present over the well of neck, extending up to the left cheek. Injury number 4, laceration of size 1.5 to so and so present on cm soft tissue depth over the left cheek, just above the angle of the mandible, left cheek. Injury 5, linear abrasion with contusion of size so and so present on the left hypochondriac region of abdomen. It is there mentioned abdomen. Lane abrasion of contusion size so and so present on the left the region of abdomen. Obliquely position. Browse position size and next point. In the postmortem, it is mentioned about abdomen injury. Now you will see PW7 is 22. Is the eye of this case. PW7 page 22. I so and so. My name is Milan Dole, so and so on oath. On 39/2017, I was working in the same capacity as in charge of so and so police outpost. On that day, I received Azahar from Sir Onil Bora. Prior to receipt of Azahar, on the same day in the morning, our one lady, namely Vandana Bora, it is the accused appellant, appeared before our police outpost. And she confessed that she was killed her husband, namely so and so, with an iron rod. Accordingly, I entered the same GD&T so and so, dated so and so. After making GD&T, I took her to the place of incident. I drew a sketch map of the place of incident. Exhibit 5 is the said sketch map wherein Exhibit 5.1 is my signature. I informed the executive magistrate to hold inquest over the dead body of the deceased. I then sent the dead body for postmortem. I also seized one iron rod on being produced by the accused person. Exhibit 3 is the signature, seizure list wherein Exhibit 3.3 is my signature in presence of witnesses. I recorded the statement of all the witnesses of this case. After completion of this work, then I reached back, the affair was lost by the Onil Bora. I sent the same to the Titawar police station for registration of the case. Then the officer in charge of Titawar police station, named as so and so, registered a case by Titawar PS case number 2233 under section 30 IPC. Exhibit 1 is the affair wherein Exhibit 1.3 is my signature, and Exhibit 1.4 is the signature of the then officer in charge of Titawar police station, which I know. I recorded the statement of the accused at the police station itself. On finding sufficient materials against the accused person, I submitted charge sheet against the accused under section 30 IPC. Exhibit 6 is the charge sheet wherein Exhibit 6.1 is my signature. Witness PW1 Sir Onil Bora stated before me that deceased used to consume liquor and used to commit atrocities on his wife and his children. On 29/9/2017, after about 9 p.m., the wife of the deceased hit my elder brother with an iron rod, to which he fell on the ground and succumbed to his injuries thereafter. Witness PW2, Sri Pranjal Bora, stated before me that last night my mother hit my father with an iron rod, to which he fell down on the ground thereafter. When I approached to pick him up, my mother obstructed me from doing so by saying that if he wakes, then he would cut us all. Next day at about 6 a.m., when I went to my house, I found my father dead. I won't be having. I started the investigation of the case after making the GD&T. It is not a fact that accused did not confess that she killed her husband with the help of iron rod. I did not record the statement of Vandana Bora, the appellant, while making the GD&T. The Azahar was registered on 30/9/2017 at about 11:15 p.m. I sent the accused to the Honorable Court on 39/2022. It is not a fact that accused did not show me the iron rod and I did not seize the same. It is not a fact that I did not record the statement of the accused at the police station itself. It is not a fact that accused did not confess before me. I have not shown the place of incident in the sketch map. this case, I did not record the statement of Makon, who used to reside near the place or residence. It is not a fact that I did not record the statement of nearby witness of the place of incident. Witness PW3 Sri Rupam Bora did not state before me that he saw the rod lying near the dead body. Witness PW4 Srimati Moni Gogoi did not state before me that Ekus told her Kali Marilu Morile. Witness PW5 Sri Vipul Bora did not state before me that he went to the house of Ekus along with many other persons, that he heard from police that Ekus has killed her husband. It is not a fact that I have not done proper investigation of the case and submitted charge sheet without any basis. From the statement of the IO said that before lodging FIR by Ekus appellant herself went to the police station, stated the fact, and thereafter police did intimate, and thereafter EW1 lodged the FIR in Indore. From page 25 is the 131 statement of the appellant, but she simply denied everything. Page 28, all she denied, all the questions that she has not nothing, she has not committed. Page 28 can be alert, please. Page 28, question number 9. Do you have anything else to say? Lastly, he was asked to the anything say. Answers, the reply is there. I have not committed any crime. I may be acquitted as I am innocent. My deceased husband was a drunkard, and he fell down on the ground and received injuries over his head. On the evening of incident, deceased came back home under influence of liquor and demanded money. I could not give money to him. I left the house out of fear and came back in the morning hour of next day and found my husband in dead condition. I cannot say how died he expired. Did you want to adduce any evidence? No. All the questions she replied. Lastly, she said she did not know. She said that she does not know how to type. And then she also said that she left her. And next day she come back. Out of fear, she left the house. In this case, Your Lordship, all the witnesses know there is no eyewitness there. All are hearsay witness. Somebody says something. Not testing that there's how the deceased died. The conflict, Your Lordship, that's just finding, Your Lordship, page 42. The trial court finding. Page 40, Your Lordship got it. Page 42, paragraph 20. Let us see what the important circumstantial evidence which appears in the evidence on record against Ekus Srimati Momi Bora, showing her involvement in the matter. It is not Momi Bora, it is Bandhana, mistake, Bandhana Bora, showing her involvement in the murder of husband. It is also mistake. This is Tokeshwar Bora and the mistake here. This is Ekus Srimati Bandhana Bora was residing with her husband, Tokeshwar Bora deceased, in the same house at the time of incident. Point 2. On the day of incident, it was all along present with his wife, that is the Ekus. With Ekus was seen last together with the deceased. The time gap between the death of deceased due to assault and the deceased being the Ekus is so short that there is no possibility that any third person or party has caused death of deceased. 4.4. Evidence of Pranjal Bora, PW2, is the son of the Ekus, who is the son of the Ekus as well as the deceased, is to the effect that on the relevant day, he visited the house of his parents at about 7 a.m. As he resided in the house of his grandfather for last 5 years, he found his father in dead condition. He asked his mother that the Ekus, that is the Ekus, how his father expired, but the Ekus told before him that he does not know how he died. This witness stated that he noticed injury on his head of the deceased father. His mother informed police regarding the incident. Police arrived at the accused house, an inquest was held with the aid of executive magistrate. He exhibited the inquest report as Exhibit 2, wherein he put his signature as Exhibit 2-1. Even hostile witness, namely Sri Anil Bora, the informant of the case, PW1, Sri Pranjal Bora, PW2, who is the son of the accused, as well as this is corroborated evidence of other witnesses that they noticed serious injuries on the head of the deceased Lokeshwar Bora at the time of incident. The IO PW7 seized the said weapon of offense, white scissor list, Exhibit 3, on being produced by accused Srimati Bandana Bora, which was exhibited by the prosecution as material with Exhibit 1. Accused could not explain anything in her statement under Section 313 CRPC as to how her husband, who was present at her house at the time of incident, died due to assault on his head by an iron instrument. In this connection, it is pertinent to mention herein that though accused in her statement under Section 313 CRPC stated that her husband Lokeshwar Bora was a drunkard, he fell down on the ground and received injuries over his head. It is further stated by the accused that on the evening of incident, her husband came back home under influence of liquor and demanded money from her. She could not give money to him. She left the house out of fear and came back in the morning hour of next day and found her husband in dead condition. But medical officer PW6 has totally ruled out this possibility during his cross-examination and specifically stated that injury found on the person of deceased could not be sustained due to falling on hard substance. The evidence of Dr. So-and-so also found to have been learned sufficient corroborated as to the said injuries on the deceased as deposed by the witnesses who has witnessed as dead body. The opinion of doctor shows that the death was instantaneous as a result of head injury sustained immediate. And there is the last page conviction is page 46. In the result, accused Bandana Bora is convicted under Section 30 IPC. Convict was the on point of sentence. She pleaded for mercy of ground that she is having 2 sons and daughters. The accused stated that she has not been convicted by any offense. She pleaded leniency. According to convict, accused Srimati Bandana is sentenced to rigorous imprisonment for life with fine of rupees 15,000 in default of payment of fine to undergo requirement 302. The period of detention already undergo of the accused is to be set up as imprisonment divided under Section 4 CRPC. In this case, she was convicted only because she is reside in the same house, but there is no eyewitness, nothing is there. But she also noticed that how the accused is dying, the deceased has died. She has stated 2 things. One said that she came back later, she left the house, and she herself informed the police here in this case. But the trial court convicted the accused appellant only because she reside in the same house.
Last in theory was applied.
That's in the only circumstances that she is reside in the same house, but there is no intent. But in the seizure I don't know, but it was not sent for forensic laboratory. It was not examined here. Not sent for forensic case. And more case in this 2 adjacent neighbor, one Makhon Gogoi and Bolin Bora, they are adjacent here, as per this case may be understood, but they are not examined in this case. What?
Who?
One Makhon Gogoi and Bolin Bora, they are adjacent neighbor, as per this case may be understood. Case 63. Your Lordship. Next page, Your Lordship, page 64. Place of occurrence A. Your Lordship, 63 page, place of A. B is the house of, next page, Your Lordship, house of Makhon Gogoi. And D is the house of one Bolin Bora. The couple is at the neighbor there, but they were not examined. The police examined all the relatives and one Gambura and Poblas are there, all are here. Only yellow, because she reside in the house of the husband, along with the husband and this. Therefore, she trial court has convicted him on it because there may be no other person except this. It says that there is no intention to kill, because only one injury is found in the head. I don't know. Maybe always, and to all that says that his brother also says, PW1 says, that he was a drunkard, always came to drink, sometimes assaulted. PW2, due to his physical torture, he was staying separately with the parents. Maybe these circumstances can hit up moment, hit one, I don't know. There is no intention, I have not found any intention to kill, nothing in this case. And it is not clear that how he died. And there is no witness, neighbor also not examined. That iron rod also not sent for forensic test. There's a doubt in this area. Go ahead, and accused also, he has stated one thing is that in the earlier night, out of fear, she left the house and next day came and she found the dead body. And his son also came next day, PW2, and found the dead body. The case only doubt, benefit doubt to go to
Do you have any authority?
maybe activity because the benefit of doubt on the criminal case.
Do you have any authority?
Authority today I have not found. I will hand over to that. One copy I have found. I will hand over your right. Okay.
He has not stated anything how that. So 106 dies, 106. To explain how he died because they both of the were inside.
The iron rod was not simple for a simple so.
Reduce sentence to 0.51. When they reduce the sentence to 0.51.
I will hand over to you. Put my style. Authority I hand over.
You handed over.
I at two I will hand over.
Oh, this is your authority.
I have completed.
I have given
I have
one.
completed.
Oh, this from you.
Yes.
From the additional 50.
Yes, my lord. One remove priority, my lord.
Appeal. Okay. This is from appeal.
This is from appellate.
Suggestion is something.
No.
No. I
I
have
have
Lordship, actually I have given one book list for another matter also and one Trimukh Maruti Kirkan. That is I'm citing like relying on right now for this
Trimukh
judgment, for
Maruti.
this matter.
Oh,
These are the matters which will be relied on in the subsequent cases. Like he has given beforehand. May I submit it first, ma'am? Make my submission first. Lordship, should I start? May I make my submission? Here, the presence of the accused person is not denied by the appellant, my lord. That she was present when the occurrence had taken place. She used to reside along with the deceased, my lord. and during a relevant point of time, although in P1 is stated, she out of fear went away from home, your lordship, but she came back. That cannot be relied upon, as because your lordship, she has himself went to the police station, and thereafter, on her behest, the crime weapon was seized, my lord, by the police, my lord. Now, in a 313, she has stated, your lordship, may I take your lordship to the, because the presence is proved, my lord, that she was there at a relevant point of time, and your lordship will kindly note the time. It was around 9 p.m. Date of incident is 29/9/2017. May straightway take your lordship to the statement made by her in 313 statement, page 28, question number 9. 28, my lord. Question number 9. Answer to question number 9. I have not committed any crime. Has your lordship got it? At page 28. I may be acquitted as I'm innocent. My deceased husband was a drunkard. Your lordship will note that part. He was a drunkard. He fell down on the ground and received injuries over his head. That part also your lordship will kindly note, that he fell down on the ground and received injuries over his head. On the evening of incident, deceased came back home after under influence of liquor and demanded money. I could not give money to him. I left the house out of fear and came back in the morning hour of next day and found my husband in dead condition. I cannot say how he died, expired. Lordship, here she said that she was a drunkard, that at the relevant point of time he was drunk, your lordship, and he fell on the ground and received injuries over his head. But your lordship, if your lordship goes peruse the post-mortem report, your lordship, at page 56, my lord. Here, my lord. Wounds and position at page 57. Abrasion with contusion of size so and so in present over left shoulder. So left shoulder here receives injury. Then next page, linear abrasion with contusion of size so and so is present over the front of neck. So your lordship will see if someone falls on the ground, lordship generally on the neck, there will be no injury, my lord. Below the pupate cartilage, linear abrasion with contusion size so and so present over wall of neck extending up to the left cheek. Laceration of size of so and so is present. Tissue depth over the left cheek just above the ankle of mandible. Linear abrasion so and so region of abdomen oblique limb position. So on the lordship neck and the abdomen he received injuries, and your lordship will kindly examine the other part, your lordship. The scalp, skull, vertebrae, scalp lacerated over the parietal region size so and so. Depth obliquely position 10 cm above the lace so and so with underlying contusion. That part is there. And now your lordship, if your lordship examines the abdomen part, if any liquor is there on examination, abdomen was, as described, peritoneum congested, contains about 2 liters of blood, both fluid and clotted. Mouth, pharynx, esophagus, pale. Stomach and its contents, pale and empty without any specific smell. So, lordship, if there would be like liquor-like substance on his stomach, your lordship, there would have been smell on the stomach, on the contents of the stomach, your lordship. Then small intestine, pale, contains glue-like substance, pale contains gas and fetus. So that he was drunk on that day, your lordship. So that post-mortem report belies that, your lordship. And apart from that, apart from the injuries received on his head, your lordship, as she has taken that plea, that he fell down on the ground, there are injuries on the other part of the body, your lordship. So, lordship, her whatever statement she has made in 313 belies the prosecution case, my lord, that he fell down, he was drunkard, your lordship. But the presence is well proved, my lord, that she only stated that she was there at a relevant point of time. And on the next day when her son came, he found her mother, your lordship. And there was extrajudicial confession before one witness, my lord. PW4, but in her cross-examination, she denies that, my lord. And police also doesn't say so, although I have not examined the 161 statement of that particular witness. But police in cross-examination says that it has been stated before him, my lord. Your lordship, then your lordship, the accused person, on receipt of the information from the accused person, police made the GD entry, but it was not exhibited, my lord. Although in the endorsement it's there. In the seizure, while making the seizure, immediately after the endorsement of the GD entry, my lord, the police went to the place of occurrence, and as produced by the accused person, the weapon of crime was seized, my lord. It was produced by the accused person. If your lordship goes into evidence of the IO, my lord, PW7. Page 23. Page 22 first, my lord. On 39/17, I was working in the same capacity as in charge of Jalukoni Bari Police Outpost. On that day, I received Ejahar from Anil Bora. Prior to the receipt of the Ejahar on the same in the morning hours, one lady, namely Bandana Bora, who is the accused person here, appeared before our police outpost, and she confessed that she had killed her husband, namely Tukesa Bora, with an iron rod. The confession to police is not admissible in the eye of law, but that part leading to discovery on the confession made by her, and lordship, the second part. Accordingly, I entered the same by GD entry number so and so on 37/17. After GD entry, I took her to the place of incident. I drew sketch map of the place of incident. Exhibit 5 is the same sketch map, wherein Exhibit 5(1) is my signature. I informed the executive magistrate to hold inquest over the dead body of the deceased. I then sent the dead body for post-mortem. I also seized an iron rod on being produced by the accused person. Exhibit 3 is the scissor list, wherein Exhibit so and so is the signature. Lordship, in the Exhibit 3, I have checked, my lord, in the scissor list, the date of endorsement of the GD entry is there, although it is not proved in the court of law, my lord. So, lordship, all these factors coupled with your lordship points out the guilt towards the accused person, that she is the culprit, because it's an exception to the circumstantial evidence, because it's a commission of offenses taken place inside the residence, my lord, of a house at 3 hours at 9 p.m. in the evening, at night, my lord, where the inmates of the house would have absolute knowledge of the fact. So explanation is needed from the side of the informant. And if the lordship, the accused person, give the false explanation which goes against the accused person. As per the evidence of lordship, the judgment, Trimukh Maruti Kirkan, your lordship, para 22, para 15 also, my lord. Lordship, para 12 onwards, may I rely on para 12? Para 12. Lordship, may I read it? In the case in hand, there is no eyewitness of the occurrence, and the case of the prosecution rests on circumstantial evidence. The normal principle in a case based on circumstantial evidence is that the circumstances from which an inference of guilt is sought to be drawn must be cogently and firmly established. That those circumstances should be of a definite tendency, unerringly pointing towards the guilt of the accused. That the circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused, and they should be incapable of explanation on any hypothesis other than that of a guilt of the accused and inconsistent with their innocence. The demand of dowry and money, all these factors are not needed. Para 14. If an offense takes place inside the privacy of a house, and in such circumstances where the assailants have all the opportunity to plan and commit the offense at a time and in circumstances of their choice, it will be extremely difficult for the prosecution to lead evidence to establish the guilt of the accused if the strict principle of circumstantial evidence, as noticed above, is insisted upon by the court. A judge does not preside over a criminal trial merely to see that no innocent man is punished, A judge also presides to see that a guilty man does not escape. Both are public duties. The law does not enjoin a duty on the prosecution to lead evidence of such character, which is almost impossible to be laid or at any rate extremely difficult to be laid. The duty on the prosecution is to lead such evidence which it is capable of leading, having regard to the facts and circumstances of the case. Here it is necessary to keep in mind Section 106 of the Evidence Act, which says that when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. Illustration appended to this section throws some light on the contents and so. Para 15, where an offense like murder is committed in secrecy inside a house, the initial burden to establish the case would undoubtedly be upon the prosecution. But the nature and amount of evidence to be laid by it to establish the charge cannot be of the same degree as is required in other cases in circumstantial evidence. The burden would be of a comparatively lighter character. In view of the Section 106 of the Evidence Act, there will be a corresponding burden on the inmates of the house to give a cogent explanation as to how the crime was committed. The inmates of the house cannot get away by simply keeping quiet and offering no explanation on the supposed premise that the burden to establish its case lies entirely upon the prosecution, and there is no duty at all on an accused to offer any explanation. Then, Your Lordship, para 22. When an accused allegedly have committed the murder of his wife and the prosecution succeeds in leading evidence to show that shortly before the commission of crime, they were seen together, or the offense takes place inside a dwelling house where the husband also normally resided. It has been consistently held that if the accused does not offer an explanation how the wife received injuries or offers an explanation which is bound to be false, it is a strong circumstance which indicates that he is responsible for the commission of the crime. In Nicara versus State of HP, it is observed that the fact that the accused alone was with his wife in the house when she was murdered there with cookery, and the fact that the relation of the accused with her was strained would, in the absence of any cogent explanation by him, point to his guilt. In Ganesh Lal versus State of Maharashtra, the appellant was prosecuted for the murder of his wife, which took place inside the house. It is observed that when the death has occurred in his custody, the appellant is under an obligation to give a plausible explanation for the cause of her death in his statement under so and so. The mere denial of the prosecution case coupled with absence of an explanation was held to be inconsistent with the innocence of the accused, but inconsistent with the hypothesis that the appellant is the prime accused in commission of the murder of his wife. In State of UP versus Dr. Ravindra Prakash Mittal, the medical evidence disclosed that the wife died of strangulation during the late night hours or early morning, and her body was set on fire after sprinkling kerosene. The defense of the husband was that the wife had committed suicide by burning herself and that he was not at home at that time. The letters written by the wife to her relative showed that the husband ill-treated her and the relationship were strained. And further, the evidence showed that both of them were in one room in the night. It was held that the chain of circumstances was complete, and it was the husband who committed the murder of his wife by strangulation, and accordingly, the court reversed the judgment of the High Court, acquitting the accused and convicted under Section 302. In the State of Tamil Nadu versus Rajendran, the wife was dead in hut which had caught fire. The evidence showed that the accused and his wife were seen together in the hut at about 9 p.m. and the accused came out in the morning through the roof when the hut had caught fire. His explanation was that it was a case of incidental fire which resulted in the death of his wife and the daughter. The medical evidence showed that the wife died due to asphyxia as a result of strangulation and not on account of burn injuries. It was held that there cannot be any hesitation to come to the conclusion that it was the accused who was the perpetrator of the crime. So here, the presence of the accused person was there, Your Lordship, my lord. The evidence of her son, Your Lordship, who subsequently remained hostile. Lordship, he told before the IO also, Lordship, but since his evidence, he has become hostile and there is no corroborative evidence to that effect, Your Lordship. So here, his evidence would be inadmissible. But other factors, Your Lordship, points out the guilt towards the accused person. That she is the perpetrator of crime. Lordship, that is my respectful submission. Your Lordship will appeal the judgment after considering the evidence on record.
What do you say about the post-mortem report?
Your
That the
Lordship,
stomach was
convicted under the 302 punishment for murder. But section 300 murder not satisfied in this case, Your Lordship, because there is no intention. Here I am reading you section 300. The IPC.
page 60.
It's Lordship,
Page 60.
Lordship.
Stomach and its contents.
Pale and empty without any smell.
Now, one side you say that he was drunk.
One set check here. Official Ranga, they said that it's as per medical report, postmortem, that on that day it was empty found. But maybe earlier it was done, get together. Smell intended and contention, pale and contents blue like.
You'll have to convince us on this issue. One side you say he was drunk. 313 you said he was drunk. Then he fell down and hit his head.
There is
Post-mortem report says no, nothing was there in the
Nothing.
stomach. What do you say on this? How do you convince us?
In this case, Your Lordship, in this case, Your Lordship, though, maybe Your Lordship convert to 304 part 2, because there is no intention. As per evidence and medical exam says that something is there, and he was in the present there, and nobody is there. But it is not the intention to kill here. 30 is not satisfied, Your Lordship. Because there is no intention to kill, and nothing is there, and no pre-plan, nothing is there, and maybe sudden provocation. The heat of moment, maybe he has hit moment, I don't know.
You have any authorities? No authorities.
The options I am submitted are not being. That too, I will hand over here. To authorities I have. Okay. Printed copy, I will. give.
When can you hand over?
Today, yes. Second half, I will. Courtmaster, I will.
But is Islam that make MS Buyan and addition PP answer? Meeting concluded. Just one.
Places.
Looks forward. No. Hmm? It's no photo na yan. Then this one there, this one. No. What is it?
Very clear. In this case, also, my name is not there, my colleague is here. So I may be allowed to argue the case on his, on being instructed by him, got it?
Okay. If you.
Right.
What is this IA?
IA is for suspension of sentence and grant of bail, but there is a order that both the matter, IA and main appeal will be taken up together, Lordship. So I am arguing the main appeal today. So here FIR, your Lordship will find page 4, starts from page 4, relevant portion page 5.
Yes.
Here the informant is the wife of the appellant, okay, as stated in the FIR, okay. But actually, she is earlier married to another person and did not obtain any divorce, Lordship. And thereafter, they were in a relationship, and due to their relationship, one child was born. And it is alleged that that child was strangulated by the present appellant. This is the main case. Page 5 is the FIR. That the complainant got married to the accused on 10th day of November / December 2010 as per social customs as well as the customs of missing community. That since 3 months after the marriage, the accused has been torturing me both mentally and physically. That the accused and I were blessed with a child on 23/5/2022 in Lakhimpur Civil Hospital. That the child was born to me through cesarean section in the medical, and during that period, as I was in an unconscious state, my husband tried to sell the child to some person, but as my mother resisted him from doing so, a chaotic situation arose there, whereupon the nurses of the medical came to know about it and prevented him from selling the child. That on 22nd day of my return to my husband's house from hospital, where I had stayed for 15 days, my husband not only assaulted my child and me at night, but also strangled my 1-month-old child to death on 30/6/2012. He also threatened me that he would cut me to death and bury me by putting me into a gunny sack in the event of my telling that this fact to other persons, and if I would act as per his dictate, I would be able to live with him peacefully. That I lodged a case with Gogamukh Police Station on 8/8/2022, whereupon the police of Gogamukh Police Station called him to the police station. The police interrogated him, settled the matter, and sent both of us to our house. That the accused left me on the road that very day with the threat that he would kill and bury me by putting me into a gunny sack in the event of my going to his house. That being helpless, I have been living near Gogamukh Sariali by taking a room on rent. In course of my stay in the rented room at Gogamukh Sariali, once my mother visited me to inquire after me. Then the accused threatened me that he would cut me to death and throw me in the river by putting me in a gunny sack. Once, when my mother came to stay with me for my security, the accused resisted her. That whenever the accused meets me on the road, when I go for making purchase, he scolds me using filthy words. On one occasion, he said to me, "You cannot do anything by lodging any case with the police station, as I have managed the police of the police station, even though I killed my child, but the police settled it at the police station. Have you understood who am I? Be careful in future, otherwise I will kidnap you someday and throw you in the water by putting you in a gunny sack." Hence, finding no alternative, I have filed this complaint. Since he sometimes visit my house at about 12 o'clock at night and calls me to go outside. I therefore pray to this. So this is the FIR, Lordship, and this FIR was lodged on 4/9/2022. 4/9/2012. Sorry, 4/9/2012. And as per FIR Lordship, date of occurrence is 36/2012.
There are two dates.
Lordship,
There are two dates of occurrence.
yes, it is in there, column number 5, page 6.
No, page 4.
Page 4 is also there, 23/5/2012 and 36/2012. That 23/5/2012, it is on, the child was born. This is the date of his birth. And second date, when it is alleged that the child was strangulated, that is 36/2012. So this case was registered under section 498A 306/506, 302/506. Now your lordship will find page 11 is the deposition of PW1.
He's an informant.
Yes.
Yes.
Accused Bhadreswar Pade is my husband. I have not been with my husband for a year. I got married to him 2 years ago. My husband used to beat and torture me since after the marriage. I gave birth to male baby in Lakhimpur Civil Hospital 1 year after the marriage. Later we returned home. After 1 month and 12 days, while my child was sleeping at night, the accused strangled him to death at 2 a.m. Taking the child, the accused went out of the house. Since I was physically unwell, the lodging of the case got delayed. I filed a complaint in the court and the case was forwarded to the police station for investigation. Exhibit 1 is my said complaint. Transfer signature. The dead body of my child could not be recovered. Police seized some clothes of my child. Exhibit 2 is the seizure list, wherein Exhibit 2(1) is my signature. So here, let's say the seizure list where the clothes of the child was recovered was laid by the informant herself after 8 months of lodging of the Azahar. Cross. Before filing this case, I also lodged a case against my husband as he had assaulted me. But I did not lodge any case over the matter of killing of the child. So the which as she was saying that the police has compromised the matter, it was relating to that assault was made to the informant by the appellant, not regarding killing. That was not the case. So this is what the cross examination clarifies it. Before filing of this case, I also lodged a case against my husband as he assaulted me. But I did not lodge any case over the matter of killing of the child. The case which I had lodged was settled in the police station itself, and my husband took me back to his house. Since the police of Gogamukh PS did carry out any investigation over the matter of killing my child, I lodged a complaint with the DIG about it. The name of my former husband is Dulal Pegu. I have not got divorced from Dulal Pegu. It is not a fact that the accused did not kill my child. I could not work since 3 weeks after my delivery. So this is the evidence of PW1. And apart from that, Lordship, there is no evidence, Lordship. No one has seen, no one has said anything. Everyone said, Lordship, they were informed by the PW1. Only this much. I am reading PW2, your Lordship, on page 13. I know accused Bhadreswar Pade. Sangeeta Pade is the wife of Bhadreswar. On a day 2 years ago, Sangeeta said that Bhadreswar had killed her child. The child was 1 month old. Police interrogated me in connection with the incident. But since police had asked me whatever I have deposed today, I did not state the same to them. That's all I have to say. It is not a fact that Sangeeta did not tell me that Bhadreswar had killed her child. PW3. I know the accused. Informant Sangeeta is the wife of accused. The incident took place about 2 years ago. The child of the accused died at night. The following day, I came to know about the death of that child. I do not know how the child died. So there is no evidence there in the PW 2 and 3 that the victim died homicidal death. That is not there. PW 4. I know the accused. I know informant Sangeeta. The informant is the wife of the accused. A son was born to them. Later, the child died. I do not know how the child died. I do not know why Sangeeta lost the case against the accused. Nowadays, Sangeeta does not live with the accused. Now, PW 5. I know the accused and informant Sangeeta. Informant Sangeeta is the wife of the accused. A son was born to them. Sangeeta said that the accused had strangled the child to death. As Sangeeta lost the case, the police came to investigate the matter. Police took my statement. It is not a fact that Sangeeta did not tell me that the accused had strangled the said child to death. It is not a fact that I have adduced false evidence. PW 6. I know the accused. A small child of the accused died and a case was lodged over that matter. Police came and I stated to the police that I did not know about the incident. I am not aware as to how the son of the accused died. Cross decline. And PW 7, page 23, Lordship. I know the accused. Sangeeta Padi is the wife of the accused. The incident took place in 2013. Sangeeta Padi said that the accused had strangled his own child to death. Police came to investigate the matter and took my statement. Cross. I did not witness the incident. I did not ask the accused anything in connection with the incident. It is not a fact that I did not state to the police about Sangeeta telling me that the accused had killed the child. It is not a fact that I have adduced false evidence. I know the accused. Sangeeta Padi is the wife of the accused. Sangeeta said that the accused had killed her child and buried it. Police came to investigate the matter. Police recorded my statement. The circle officer and the police got a pit dog suspecting that the dead body of the child might be buried there. But the dead body was not found there. Baby powder, baby clothes, and gamusa were seized through Exhibit 2. And Exhibit 2 is my signature in the seizure list. Material exhibits are the said gamusa, baby cloth, and baby powder, respectively, which I have seen in the court today. So these are the only things which is recovered by the police. PW 9. I know both the accused and the informant. A son was born to Sangeeta and the accused. Sangeeta said that the accused had strangled the child to death. I know that Sangeeta lodged an Azahar with the police. Cross. Police did not record my statement. It is not a fact that Sangeeta did not tell me that the accused had strangled the child to death. It is not a fact that police recorded my statement. It is not a fact that since I did not state before police about Sangeeta's telling me that accused had strangulated the child to death, I have stated before the court today that the police did not record my statement. PW 10. The accused is my son-in-law. Informant is my daughter. They had a male child. The child died 1 month and 12 days after its birth. My daughter Sangeeta said that the accused had strangled the child to death. So here, Lordship, may I see the word, The child died 1 month and 12 days after its birth. So there is no allegation by the mother-in-law. Only said died, and only information was given by the daughter of the PW10. My daughter Sangita said that the accused had strangled the child to death. My daughter lodged an Azhar with the police station. Police came and recorded my statement. Cross. At present, Sangita has no child. Sangita had married another person before her marriage with the accused. It is not a fact that Sangita has 3 children by the names of Ranjan, Michael, and Kamal, fathered by her former husband. It is not a fact that at the time of death of child, Ranjan, Michael, and Kamal were along with the accused and Sangita. It is not a fact that Sangita did not tell me that the accused had strangled the child to death. It is not a fact that Sangita lodged the case against the accused on false grounds and that I have adduced false evidence. PW 11, he is the IO of the case, page 31. Okay. On 22/10/2012, I was on duty as attached officer in Gogamukh police station. On that day, the officer in charge of the police station entrusted me with the task of completing the remaining part of the investigation of Gogamukh PS case number 141 of 2012 under section so. SI Tuchen Sutia of the PS did the investigation into the case. After going through the case diary, I found that some part of the investigation was yet to be completed. I arrested the accused and forwarded him to the court. On being shown by the informant, I made effort to recover dead body in presence of the magistrate from the place where it had been buried. But we did not find the dead body. I recovered 2 gamusa, some baby powder, baby clothes, and baby powder. So here, your lordship may kindly note that on being shown by the informant. So these were the place was shown by the informant. It was not the appellant. I have seen the said 2 gamusas, material exhibit 1, baby clothes, material exhibit 2, and baby powder, material exhibit 3 in the court today. I prepared the seizure list. Exhibit 2 is the seizure list and exhibit 3 is my signature therein. I recorded the statement. I recorded the statements of witnesses Onu Panging, Ingti Borua, and Ghonokanto Pegu. On completion of investigation, I submitted the charge sheet against the accused upon finding incriminating materials of committing offense under section 498A-302-506 IPC. Cross. Earlier, the informant had married another person. The place to which the informant led us, saying that her child had been buried there, is about 1 kilometer away from the house of the informant. The informant did not tell me as to who had buried the dead body in that place. The informant did not also state to me as to from whom she could learn that the dead body had been buried in that place. It is not a fact that I submitted the charge sheet of this case without investigating into the matter properly. Now, PW 12. I am serving as the in charge of Guijan OP. On 6/9/2012, I was serving as attached officer at Gogamukh police station. On that day, Sangita Padi lodged a complaint before the CGM Dhemaji, and the same was forwarded to Gogamukh police station by the court. The OC Hogendra Nath Das registered the same as Gogamukh PS case number so-and-so. I was entrusted with the case. I then took the statement of the complainant and another witnesses, visited the PO and drew a sketch map. The accused could not be arrested. Thereafter, I was transferred and I handed over the case diary to the OC. And in 313, he denied the allegation. And in page 36, he says that they had child, but he did not kill him. So here, Lordship, the prosecution has exhibited the FIR, the seizure list, charge sheet, these 3 documents. And apart from this, there is nothing on record. And my case before my case is that, Lordship, the prosecution in the present case has failed to prove that the victim, that the child of the informant died homicidal death to convict the appellant under section 302. And there is delay in lodging the Azahar and delay in recovering those articles, which also shows that that there is some inimical relation between the informant and the appellant. Because earlier she has filed a case under section for assaulting her by the appellant, which was settled by the police. Subsequently, after 8 months of the incident, she led the police and shows those baby powder, gamusa, and those things. So there is probability of false implication, Lord. And just I'm relying on 2 judgments, Lordship, where Madhav Singh, that Madhav Singh versus State of Rajasthan. Paragraph 8, Lordship. Paragraph 8, it will last paragraph. In the absence of proof of homicidal death, the appellants cannot be convicted merely on the theory of last seen, they having gone with the deceased in the manner noticed herein above, herein before. The appellant's conviction cannot be maintained merely on suspicion, however strong it may be, or on their conduct. These facts assume further importance on account of the absence of proof of motive, particularly when it is proved that all the 3 were good friends for over a decade. So here also motive is also motive is absent. And next Rishipal versus State of Uttarakhand, you will receive paragraph 10, 14, 15, and 19, Lordship. Paragraph 10, 14, 15, and 19.
Yes.
Paragraph 10, Lordship. Coming next to the question whether the prosecution has brought home the charge of murder leveled against the appellant, we must at the outset point out that the case is entirely based on circumstantial evidence. No direct evidence has been adduced to prove that Abdul Mahbud, whose corpus delicti has not been recovered, was done to death, nor any evidence adduced to show where and when the same was disposed of by the appellant, assuming that he had committed the crime alleged against him. So here also that it was not shown that when and how the body was disposed of. And if the body was disposed of by the appellant, how she came to know that those articles were hidden in that place, that baby powder, gamusa, those things, Lordship. Now paragraph 14 may Lordship kindly may see. Paragraph 14. In the absence of corpus delicti, what the court looks for is clinching evidence that proves that the victim has been done to death. Here there is no clinching evidence to show that victim was died homicidal death. If the prosecution is successful in proving cogent and satisfactory proof of the victim having met a homicidal death, absence of corpus delicti will not by itself be fatal to a charge of murder. Failure of the prosecution to assemble such evidence will, however, result in failure of the most essential requirement in a case involving a charge of murder. That is precisely the position in the case at hand. There is no evidence, either direct or circumstantial, about Abdul Mabud having made a homicidal death. The charge of murder leveled against the appellant, therefore, rests on a rather tenuous ground of the two having been last seen together, to which aspect we shall presently advert when we examine whether the two being last seen together is proved as a circumstance and can support a charge of murder. Now, paragraph 15, Lordship. The second aspect to which we must straightway refer is the absence of motive of the appellant to commit the alleged murder of Abdul Mahmood. It is not the case of the prosecution that there exists any enmity between Abdul Mahmood and the appellant, nor there is any evidence to prove such enmity. All that was suggested by the learned counsel appearing for the state was that the appellant got rid of Abdul Mahmood by killing him because he intended to take away the car which the complainant, Dr. Mahmood Alam, had given to him. The argument has not impressed us. If the motive behind the alleged murder was to somehow take away the car, it was not necessary for the appellant to kill the deceased, for the car could be taken away even without physically harming Abdul Mahmood. It was not as though Abdul Mahmood was driving the car and was in control thereof, so that without removing him from the scene, it was difficult for the appellant to succeed in his design. The prosecution case, on the contrary, is that the appellant had induced the complainant to part with the car and as a sum of rupees 15,000. The appellant has been rightly convicted for the fraudulent act, which conviction we have affirmed. Such being the position, the car was already in the possession and control of the appellant, and all that he was required to do was to drop Mehboob at any place and road to take away the car, which he had ample opportunity to do during all the time the two were together while visiting different places. Suffice it to say that the motive of the alleged murder is as weak as it sounds illogical to us. It is fairly well settled that account of the incident it assumes importance in cases that rest entirely on circumstantial evidence. The absence of strong motive in the present case, therefore, is something that cannot be lightly brushed aside. Now, paragraph 19, Lordship may receive. It is true that telltale circumstance prove on the basis of the evidence on record give rise to a suspicion against the appellant. But suspicion, however strong, is not enough to justify conviction of the appellant for murder. The trial court has, in our opinion, proceeded more on the basis on the appellant may be murdered the deceased Abdul Mahmood. In doing so, the trial court overlooked the fact that there is a long distance between may have and must have, which distance must be traversed by the prosecution by producing cogent and reliable evidence. No such evidence is unfortunately forthcoming in the instant case. The legal position on the subject is well settled and does not require any retaliation. This is the judgment, Lordship. And just I'm taking to your Lordship to the chart sheet, Lordship. Page 52. Relevant portion, your Lordship will find page 56. Page 56, I am reading, Lordship.
Yes.
In course of the investigation, Lordship, go ahead. Second paragraph, Lordship. Top fifth line, Lordship. In
Yeah.
course of investigation, the place of occurrence was visited and witnesses were examined. The complainant was interrogated and the sketch map of the place of occurrence was drawn as shown by the complainant. The place where complainant's son had been kept buried was dug in presence of executive magistrate so-and-so, but no dead body was found. On the other hand, the Ejahar was lost after 2 months of the incident, and the place where the dead body had been kept buried was shown 8 months after the incident. So the informant has shown it after 8 months. That is what I was placing for your lordship. And she has not stated from whom she came to know that those things are kept there, Lord. By whom, it is also not mentioned. So this is the case, Lordship. In my submission, I will say, Lordship, there is no evidence to connect the appellant with the alleged offense, Lord. And there is no proof that the victim alleged victim has died a homicidal death to convict the appellant under section 302. Because to convict him, there has to be a homicidal death. Lord. I will reply to you after my current senior friend submit. Lord.
Lordship, I have made this submission on the earlier occasion when the matter came up. Lordship, apart from your Lordship, there's a delay in lodging the FIR. She being the mother of the child, she's set over the matter for 2 months. Although she says she was unwell, that's why there's delay, but it's considered a delay of 2 months lodging the FIR. And about only that parties there that she informed certain witnesses to PW 5, 7, 8, and 9 as well as to 10. She informed that the accused person is killed. In substantive evidence, they have stated that apart from that, I don't find, I will be wrong in submitting my, but I did not find on record, evidence on record, any other material which goes against the accused person. Lordship, that is my response. Probably he's behind the bars.
From the date of judgment. Almost
of
5 years, 8 months. Lordship.
5 years.
8 months. Lordship.
Lordship.
You put
A Ahmed. Lord.
here.
A Ahmed.
Okay, Ahmed. Council of Affluent. Also heard MSB Boyan. Hearing concluded. Judgment reserved.
Obliged.
Lordship 302, my lord. My lord, here in this case, my lord, rigorous imprisonment for life, my lord, and a fine of rupees 5,000. My lord, fine of rupees 3,000, my lord. In default, 6 months, my lord. My lord would find the FIR at page 3, my lord. The informant is the sister of the deceased, my lord. Younger sister of the deceased, my lord. May I read the Ejahar, my lord?
Yes.
Humble submission is that at about 11 p.m. last night, that is to say on 13/3/17, my lord, a portion of the test was found omitted in the original, my lord. My elder sister Helena Kisku, 28 years, was brutally assaulted with bamboo stick and branch of a tree, as a result of which my sister died in the house of the accused. Today on 14/3/17, I had gone to the house of my sister and saw her dead. And later on, I came to know that. So, my lord, she's not the eyewitness. Later on, I came to know that she was killed by my brother-in-law. Therefore, it is paid to take necessary steps in this regards after investigating into the matter. So, my lord, here in this case, my lord, altogether 8 witnesses were examined, my lord. And the informant was examined as PW1, my lord. And my lord will find PW1 at page 8. My lord, PW1 Susmita Kisku, the sister of the deceased, my lord. I know Baska. My lord, this is the nickname of this person, my lord. I know
Informant.
Baska.
This is the informant.
Yes, this is the informant, my lord. Susmita Kisku, PW1 is the informant, my lord. I know Baska, the accused. On 13/3/17, the incident occurred at around 11 p.m. The accused killed Helena Kisku at night, his wife. He assaulted his wife to kill him. I heard the sound shouting on assaulting her to kill her. Now she says that he had heard. He assaulted Helena by stick. The stick bamboo used to kill Helena by the accused. I saw lying the dead body. Whole body was wounded due to assault. I lost the FIR. Now, my lord, page 9, lordship would find the cross-examination. I reside nearer to the accused. The distance is, my lord, would note 1 kilometer in between our residence. 1 kilometer, my lord. I was at my residence on 13/3/17 at that time of incident. It is not a fact that I did not hear the shouting at the time of assaulting Helena by accused. Police recorded my statement. I said the incident to the police. It is not a fact that I did say it at FIR and in the statement to the police. I heard sound. I did not see the incident. So she did not see the incident. It is not a fact that I did not say on leading to the police. I did not inform others at night. She did not inform. I was alone at night at my residence. The accused confessed guilt. Now, my lord, this is important, my lord, because, my lord, here in this case, my lord, the extrajudicial confession is tried to be brought on record, my lord, in order to sentence the accused persons, my lord. For that, my lord, it is not a fact that accused was outside on the day of incident. It is not a fact that victim was killed by others. Now, my lord, this is important, my lord. The villagers were present at confessing the guilt. So, my lord, she names 3 persons, my lord. Sanjay Mardi, Labi Mardi, Lokhiram Soren, my lord. And now, my lord, in this entire case, my lord, these 3 witnesses have not been examined, my lord. Because your lordship would find in the paper book, on the 2nd page, your lordship would find the index, my lord. There, your lordship would find that these 3 persons, Sanjay Mardi, Labi Mardi, and Lakhiram Soren, they are not examined anywhere, my lord, in the entire case, my lord. Was available at the time of confessing the guilt. The villagers handed over to police. The accused used stick to kill Helena. The bamboo sticks are available at everybody's house. So, my lord, this is PW1. So, she is not an eyewitness, my lord. Now, PW2 at page 10, my lord.
Who's PW2?
This is, my lord, Maben Marak, but it should have been Naben Marak. He is one of the Caesar witness, my lord. Because your lordship, for a moment, I'll just take your lordship to page 39, my lord. This Caesar list, for a moment only, 39.
Yes.
My lord would find 1 broken wood branch, then 1 piece of bamboo with hair and blood stain, 1 piece of cloth with blood stain. Now, my lord would, at page 40, lordship would find only 2 persons as these Caesar witnesses, my lord. Naben Marak, this is PW2, my lord, and Rogot Tudu, my lord, PW3. These are only the 2 witnesses, my lord. Now, my lord, I'll come to page 10, my lord. I'm reading, my lord. I know the accused. I know the informant. Susmita's sister. The victim's my sister-in-law. So interested witness, my lord. My contention before the lordship is that he is an interested witness. I'll show why. The incident occurred 6 months ago. The night the incident occurred, the accused killed Helena at night. The accused confessed guilt before me. Now, my lord, he says accused confessed guilt before me, whereas PW1 says that 3 persons were there. He was not the person who was present there at the time when the accused made the confession, as far as PW1 is concerned, my lord. Now, my lord, we turn to page 11, my lord, the cross part. Now, this is interesting, my lord. Police did not ask me about the incident, meaning thereby he never deposed before the police, my lord. Police took my signature. I don't know why the police took my signature. And my lord, in the chief, he says that she is my sister-in-law, the deceased, my lord, as well as the informant, my lord. So in that way, my lord, I'll just place the person as an interested witness. I know, my lord, there are decisions of Supreme Court which says that if a person is an interested witness, the entire evidence should not be discarded. That has to be corroborated with the other evidence available on record. This is what the Supreme Court says. But my lord, since when he in the cross-examination he says that police did not took my statement, meaning thereby the person should not have been a witness to the charge sheet, my lord. Because if I am being an investigation officer, I am going to bring on record only those persons as witnesses in my case, those who have given their statement or I personally have taken their statements. But I would not call randomly a person as witness. Even if, for the sake of argument, my lord, I'll say that he was a Caesar witness. To that he says that I do not know why the police took my signature, meaning thereby that the paper was plain. He was never informed that since we are seizuring these particular articles, so we need you as a witness, my lord. That information was also not placed before the accused, my lord. Now, my lord, PW3, page 12, my lord. Here also, my lord, very same submission would be there. He is an interested witness, my lord. My lord, I'll read. I know the accused, I know the informant. The deceased is my sister, cousin. She is my sister means she is her cousin. The incident occurred at the night on the day of Holi. My lord, this is important, my lord. The accused confessed to me he killed his wife. My lord, this person was present is been not stated by the PW1 informant, my lord. I saw the dead body of Helena at the morning. Exhibit 2 is my signature on the seizure list. The accused killed Helena by bamboo stick. Now, my lord, would see at page 13, cross, my lord. I did not say about killing Helena by Baska to the police. Police took my signature. Police took signature of me on a paper. I do not know the reason of taking my signatures. So, my lord, these two are the Caesar witnesses, my lord. And about the, my lord, confessional statement and other, nothing is there, man. And that apart, my lord, he himself says that the deceased as well as the informant are his sister, my lord, cousin sister, my lord. So, my lord, apart from that, and neither they have said that they have seen the incident. Since, my lord, one of the family members files an FIR against me, the other family persons are supporting, but in the cross, my lord, they themselves are discarding their evidence which they have placed under 161 or before the court, man, saying that we don't even know about the incident. Neither we have said that he has killed. Now, I'll come to page 14, my lord. PW 4, my lord. So, Murmu. My lord, as per this sketch map, my lord, this person's residence is in between the residence of, my lord, the informant and the deceased man, as per this sketch map, my lord. I know the informant, I know the accused. The incident occurred on the day of Holi. The accused committed the offense of murder. Baska killed his wife, Helena, at night. I visited the residence of accused. The victim was lying dead in injuries of all her body. The accused killed Helena, confessed before us. He showed us the stick of killing Helena. So, my lord, first part is that since the informant never says about this person being present when the accused made the confession, because she has stated 3 different names, my lord. He is not the person. Now, my lord, page 15 is the cross, my lord. I did not see killing Helena. It is not a fact that Baksa did not confess before me that he killed Helena. It is not a fact that I deposed falsely today. Now, my lord, page 16, PW5, my lord. I know the accused, I know the informant. The incident occurred 6 months ago. The accused killed Helena by assaulting. The day of Holi, the incident occurred. Helena was killed hurting at the tender parts of her body. I saw the dead body at morning. The accused confessed killing the victim Helena before the police. Now he says before the police, my lord. However, his name is also not been taken by the informant, my lord. Page 17, he says, I did not see the killing of Helena by accused. It is not a fact that accused did not confess his guilt to the police. It is not a fact I deposed falsely, my lord. Now, my lord, PW6 is the doctor who conducted the postmortem, my lord.
Yes.
On 14/3/17, I conducted the postmortem examination of Helena Kisku, female, 28 years, in connection with Tipkai OP GD number 195 dated 14/3/17 and found the following. An average built female dead body of approximately 40 years, examined, rigors mortis present, clotted blood seen in both lower limb and clothes, bruises seen in multiple in numbers in both upper limb and lower limb and back of the chest, multiple tear of anal and clotted blood following performating injury. And there is complete fracture of right upper end of humerus, both collection of blood around the soft tissue. In my opinion, the cause of death is neurogenic shock and hemorrhage following hit by a blunt weapon of high velocity, which is anti-mortem in nature, and the time of death is 12 to 16 hours. Exhibit 2 is my report, Exhibit 2 is my signature, and the cross was declined, my lord, in this case. Now, my lord, PW7 is the sub-inspector who did the, my lord, initial part of investigation. However, the charge sheet was filed by the officer in charge, my lord. Page 19, my lord, PW7. On 14/3/17, I was working as the in charge of Rupashi Police Outpost. On that day at about 9:30 AM, one Susmita Kismu came to our OP and informed that her sister has been killed by the accused. Accordingly, informing the officer in charge of Bogri PS, I visited to the place of occurrence with my staff, making a GD white number 195 dated 14/3/17 in the OP. When I reached to the house of the accused, I saw the dead body of Helena Kisku in the house of the accused, and he was also present at that time. Accordingly, I apprehended the accused, drawn the sketch map of the PO, and recorded the statement of witness. Exhibit 3 is the sketch map, and Exhibit 3(1) is my signature. Inquest of the dead body was done by the magistrate, and thereafter I sent the dead body for PM examination. After completion of investigation and collecting the PM report, I also filed the charge sheet against the said accused Barka Murmu under section 302 IPC. Exhibit 4 is the charge sheet and Exhibit 4(1) is my signature. During investigation, I seized one broken branch of a tree and one bamboo lathi with blood stain, and also seized one piece of cloth of sari with blood stain. Exhibit 2 is the seizure list prepared by me. Exhibit 2(3) is my signature. I saw the seized article in the court today. Material Exhibit 1 is one broken branch of a tree. Material Exhibit 2 is one piece of bamboo lathi with hair and blood stain, and Material Exhibit 3 is one piece of cloth with blood stain. Now, my lord, cross-examination at page 20, my lord. Most of the part of investigation was done on the basis of GD. I also recorded the statement of witnesses on the basis of GD. I have not furnished the extract copy of GD along with the charge sheet. I seized the item from the place of occurrence which was shown by the accused, but not from the possession of the accused. Though I got mark of blood stain in the bamboo stick, I have not sent it to FSL for examination. So, my lord, I'll be relying on two of the judgments, my lord, one of this honorable court and other from the full bench of the Supreme Court, my lord. If the material exhibits are not sent for, my lord, FSL, what should be taken up thereafter, my lord? I have not sent it for FSL for examination. The house of the informant is about half kilometer far from the house of accused. It is not a fact that accused did not kill his wife Helena. The accused is confessed before me, but I have not sent him to record his confessional statement. Now he says that he confessed, but he did not put him before the magistrate to record under statement under 164, my lord. Now, page 21, my lord, again he was re-examined, my lord. At the time of filing the charge sheet, I did not file extract copy of GD. As per order of the court, I produced the certified copy of GD entry. Exhibit 5 is the extract of GD and exhibit 5.1 and 5.2 are my signature. Now, my lord, PW8 is the, my lord, executive magistrate who conducted the inquest, my lord, over the dead body, my lord. Page 22, my lord. On 14th, I'm reading, my lord. On 14/3/17, I was working as extra assistant commissioner at Parvat Johra. On that day, I made an inquest of a dead body of female at about 11:25 a.m. at 60 Matha, Part 3, under Bogibari PS. The name of the disease was Helena Kisku. At the time of death, she was facing in the upward direction and her head was facing in the eastern side. The injury marks seen on both sides of her hands and legs and lower back side. Blood was visible on lower back of the dead body near private area. I have done the inquest in presence of witness Som Murmu, son of Silbilal Murmu, and Rogot Tudu, son of late Ganesh Tudu. So, my lord, page 23 is the 313, my lord. My lord, in the 313, my lord, he has declined all the questions which were put forward to the accused, my lord, at the time of 313, my lord. Only, my lord, he says he has taken a plea of alibi, my lord. But however, my lord, in this case, the accused did not adduce any defense witness, my lord. My lord, he should have adduced the evidence if he has taken the plea of alibi. But in this case, my lord, he did not did not brought the witness for the court. Had he done so, my lord, then the case could have been clear, my lord. But this is one part, my lord, which goes against him, my lord. My lord, page 24, last question, my lord, question number 4, my lord. Do you want to say anything? Yes, I am innocent. At the time of incident, I was not present in my home. At that time, I was at my brother's house, but the brother was not examined. This is my lord. Now, page 25 is somehow, my lord, important, my lord, because hearing on sentence or hearing of the accused, my lord, page 25, my lord. In the answer part, my lord, the accused says that I am a very poor person and there is none to after my family and 3 minor children, and hence I pray for leniency and accordingly pray for lesser sentence. So now, my lord, even if there were 3 minor children, my lord, the police never, the investigation never took any endeavor to take the statement of these witnesses. Because, my lord, why I say so? Being an amicus, my lord, of this court, my lord, my first submission would be that, my lord, the provision of section 106. 106 of the Evidence Act will come, my lord. Because being a husband, my lord, I am to give a particular explanation as to where was myself when the incident took place, my lord. Just as my lord 103, my lord. I'll just take your lordship to 103 first, my lord. Burden of proof as to particular fact. The burden of proof as to any particular fact lies on that person who wishes the court to believe in his existence. Unless it is proved by any law that the proof of that fact lies on any particular person. So, my lord, since myself and the deceased, my lord, were husband and wife, my lord, and the occurrence, my lord, even if, my lord, we presume that as far as the FIR is concerned, my lord, it happened around 11:30 in the night, my lord. So, my lord, there has to be a plausible explanation from the accused. Where was he at the time when the incident took place? However, this part, my lord, the accused has failed, my lord. Because once he take a plea of LEB, my lord, so under 103, my lord, he is required to bring on evidence in defense. Now, my lord, even if that be the case, my lord, since it was holy, my lord, in that particular festival, generally it is presumed that the persons who people are drunk on that particular day, they never turn to their place of residence, my lord, because on that day, my lord, the people are in an abbreviated positions, my lord. They take wine, my lord, badly, my lord, all over the country, my lord. Only on that particular day. So, my lord, that was a holy night. But one part is there, my lord. The evidence is not that definite that I have killed, my lord. First part, I'll place that submission. Even only if 103 is discarded, my lord. Now, my lord, the circumstantial evidence does not bring me within the preview of that I have committed, because of the fact the very first submission which I'll make before this honorable court is that even those interested witnesses were there before the court, my lord. They haven't deposed before the court that I had any strained relationship with my wife, or they haven't said about any previous dispute between myself and my wife, meaning thereby that our relationship were always cordial, my lord. And as far as the injuries which are there in the, my lord, body of the deceased, my lord, those are somehow said to be brutal in nature, my lord. The anal part, there itself blood coming out, my lord. Backside of the back, my lord, injuries were there, both hands were there. And my lord, heavy force was made on the head, my lord. And the head was the only injury by which she died, my lord. Other injuries were not that fatal, my lord. But the single injury which was made on the head of the deceased, my lord, that was fatal, my lord. For that she expired. Now, my lord, as far as circumstantial evidence is concerned, my lord, extrajudicial confession is there, my lord. I'll rely on the judgment of the Honorable Supreme Court. I'll just give the copies, my lord. Where are they? Oh, yeah, no, cool. My lord, internal page 4, my lord, para 7, my lord. This is on, my lord, circumstantial evidence, my lord. Para 7, my lord. Internal page 4, my lord. At the outset, it may be stated that undisputedly the entire case of prosecution rests on the circumstantial evidence, as there was no eyewitness to the alleged incident. The law on the appreciation of circumstantial evidence is also well settled. The circumstances concerned must or should be established and not may be established, as held in Shivaji Sabharao Bhobde versus the state of Maharashtra. The accused must be and not merely may be guilty before a court can convict him. The conclusion of guilt arrived at must be sure conclusion and must not be based on vague conjectures. The entire chain of circumstances on which the conclusion of guilt is to be drawn should be fully established and should not leave any reasonable ground for the conclusion consistent with the innocence of the accused. The 5 golden principles enumerated in case of Sharad Virdichan Sarda versus State of Maharashtra laid down in para 150 may be reproduced herein for ready reference. A close analysis of this decision would show that the following condition must be fulfilled before a case against an accused can be said to be fully established. The circumstances from which the conclusion of guilt is to be drawn should be fully established. It may be noted here that this court indicated that the circumstances concerned must or should and not may be established. There is not a grammatical but a legal distinction between may be proved and must be or should be proved, as was held by this court in so and so. Certainly, it is a primary principle that accused must be and not merely may be guilty before a court can convict, and the mental distance between may be and must be is long and divides vague conjecture from sure conclusions. The facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved. And there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probabilities the act must have been done by the accused. So, my lord, once the injuries are seen in brutal nature, my lord, if, my lord, had I any scuffle with my bike, I could have given a single blow to her head and she would have expired. But the nature of injuries, my lord, because, my lord, it is not the evidence of the prosecution that there was strained relationship between myself and my wife, my lord. Even the sister files the affair, but the evidence she never says so, my lord. The other 2 brothers, my lord, who came to the court, my lord, they haven't deposed that there was strained relationship, and previously also they have seen both of them quarreling or something like that, my lord. So that part is missing, my lord. Now, my lord, I'll rely on a judgment of this full bench of Supreme Court, my lord, 2020-2010 SCC 733. 2000? My lord, this judgment was authored by my lord Justice Rishikesh Roy, my lord. My lord, internal page 3, my lord. 8.1, my lord. 8.1, my lord. May I read, my lord? The alleged weapons of assault recovered on the basis of statement of the accused could be a key evidence to support the prosecution. But unfortunately, the recovered articles were never linked to the crime. The police sent them to the CHC for examination, and the CHC doctor had stated that the injuries found on the body could have been caused by those weapons. However, in his cross-examination, doctor admitted that the blood stain or other marks on the exhibit could not be seen. The weapons were reportedly sent for chemical examination, although the trial court had referred to the report of the chemical analysis to conclude the presence of blood on the exhibit, but the purported chemical analysis report is not found available with the case record. Moreover, there is no mention of any such report in the High Court judgment. This would suggest that the prosecution did not produce the chemical analysis report in the case. The relevant forensic evidence for the seized shirt supposedly worn by the accused Jagan Ram acquitted by the High Court was withheld by the prosecution. When such vital forensic evidence is kept away, and adverse events will have to be drawn against the prosecution. So, my lord, my thing is that it was not sent for chemical analysis. That is what, my lord, I'll rely on the judgment of our High Court, my lord. This was reported in 2022 GLR 506, my lord. My lord, internal page 3, my lord. Para 15, my lord. Last para, my lord.
Yes.
PW1 stated that on the following day, police recovered a dao being the weapon of offense. The PW6 stated that Motilal Garg confessed before the police that dao used in the offense was kept concealed under a pillow. PW6 further stated that though the accused led the police to the place where the dao was kept hidden, no dao could be found under the pillow. But later on, the brother of the accused has shown the place where the dao was hidden, and thereafter the police recovered the same from the jungle near a pond. According to PW7, he accompanied the police to the house of the accused Motilal Garg, and on being asked, the family members of the accused Motilal had shown the place where the accused has concealed the dao, and thereafter the police recovered the dao from the jungle near a pond. The PW8, the investigation officer, deposed that on the basis of the disclosure statement of the accused appellant Motilal, he recovered the dao from a pond, which was seized by Exhibit 6. What is evident from the oral testimony of this witness, including the investigation officer, is that a dao was recovered on being shown by the family members of the appellant Motilal Garg. However, the said dao was not sent for forensic and serological test. Although all the witness stated about the matched dao, the scissor list Exhibit 6 shows that the dao seized by police was a committee dao, but be that as it may, on the basis of the evidence on record, more particularly the testimony of the scissor witness, it cannot be said for certain that the alleged dao was recovered on being led by the appellants. Because, my lord, in the police statement, it was stated that the lathis and the branch of tree was recovered, but not from the possession of the accused. In our case also, my lord. Be that as it may, on the basis of the evidence on record, more particularly the testimony of the scissor witness, it cannot be said for certain that the alleged dao was recovered on being led by the appellants. Evidently, the seized dao was not sent for chemical or serological test. In absence of chemical and serological test of the so-called weapons of offense, merely recovery of weapon dao may be of no use to the prosecution in the present case, inasmuch as there is no evidence on record to connect dao seized with so-and-so with the commission of the offense. True it is, the lapse on the part of the investigation officer or non-examination of the witness by a chemical expert for serological test may not in all cases affect the prosecution. But in a case which rests solely on circumstantial evidence, unless the weapon of offense is subject to serological test, prosecution would be deprived of any link evidence to connect the weapon with the commission of offense. Therefore, in the present case, non-examination of the weapon for serological test is fatal for the prosecution. In the absence of serological test, prosecution is left with no evidence to connect the seized dao with the commission of offense. Therefore, in our considered view, the so-called recovery of weapon in the instant case is all of no use to the prosecution in the absence of chemical test. So, my lord, in case where the entire case rests upon circumstantial evidence, my lord, then, my lord, those evidence should be sent to FSL for examination, my lord. Because even otherwise, if the blood stain were recovered, my lord, it should have been matched with the deceased, my lord, sample also. Or even otherwise, my lord, if there had been a sample with any other person, then the blood sample could have at least shown or brought on some evidence for the prosecution to indict this particular accused in the case, my lord. So that was not done in this case, my lord. And the lordship, the judgment starts from, my lord, page 26, my lord. However, my lord would find the learned code below, my lord, actually, my lord, has page 31 has taken, my lord, the extrajudicial confession and circumstantial evidence to be the prime cause for convicting the accused. My lord, from para 19, page 31, your lordship would find, because the evidences I've already read over, my lord. Page 31, para 19, my lord.
Yes, read.
So from the above testimonies of the prosecution witnesses, the entire prosecution case is based on circumstantial evidence and extrajudicial confession statement. It is admitted position that the deceased was the wife of the accused and her dead body was found lying inside the house of the accused with multiple injuries on her body. Accused during entire trial did not take any specific plea except some suggestion put to the mouth of the prosecution witness which they denied accordingly. So the presence of the accused along with the dead body of his wife is not disputed. From the evidence of IO also it is seen that when he visited the place of occurrence on receipt of an information from the PW1 sister of the deceased, he saw the dead body of the deceased in the house of the accused, and at that time accused was also present. Thus, not only the others witness of the prosecution, but IO himself stated in evidence that he recovered the body of the deceased in presence of the accused from his house. While recording the statement of the accused under 313 CRPC, he took the plea of alibi and stated that he was not present in the night of occurrence in the house and was present in his brother's house. But the defense failed to examine the brother of the accused to prove his plea of alibi, and the accused did not take any such specific plea or plea of alibi during the entire trial of the case. More so, burden lies on the defense to prove the plea of alibi. Merely a statement of the accused is not sufficient to prove the same. So, my lord, hearing this case, one aspect I'll place before this honorable court is that even if page 25 is seen, my lord, hearing of sentence, my lord, the accused has given his thumb impression, my lord. That apart, my lord, this evidence is such vital, and he being in custody, he was never outside the custody, my lord. So meaning thereby that if he wants to bring on an evidence on record, my lord, if he wants to bring the brother on for evidence, my lord, he was not in a position to do so, my lord. Because of the fact, my lord, first, he was not that conversant with the law that if he brings on the evidence, my lord, then at least he would be able to prove his defense first part, my lord. Second part, admittedly, he was in custody, my lord. He was never released on bail in this case, my lord. And third part, my lord, that lack of communication between the advocate and the accused might be a other reason, my lord. Because, my lord, if the plea of alibi is taken, my lord, then at least a single date could have been taken by the counsel in order to bring the brother in for evidence, my lord. But that was not done, my lord. Now, my lord, para 20. So it is scrutinized whether circumstantial evidence lead to inspire confidence of guilt. The principle governing the law of circumstantial evidence are so and so. Well, as far as circumstantial evidence is concerned, well, I have already placed two of the judgments of the Supreme Court, my lord. Those are very clear that, my lord, it must be. Maybe will not do, my lord. But, my lord, my aspect, which brings some doubt in the case is that, my lord, none of the witnesses have stated that there was strained relationship between the husband and wife, my lord. That about the second part is that, my lord, nobody has seen the incident, my lord. Third part is that there were 3 minor children, but the investigation officer never tried. My lord, had been such brutal, certain aspect would have been there at the place, my lord. His sons would have woke up, my lord. Or the children would have woke up, my lord. But the prosecution never tried to examine those people's, my lord. Those minors, my lord. Even, my lord, some endeavors should have been taken by the prosecution, my lord. Now, my lord, the third aspect is that, my lord, these seizure witness also do not say that in their presence it was seized. They merely say that their signatures were taken on by the police, my lord. But however, the police never took their statements, my lord. But only difficulty on the part of the defense is that, my lord, 103 explanation is not there. That should have been there. In my humble submission, my lord, since my lord 103 explanation was not there on the part of the accused, my lord, he has been convicted, my lord. Because at the end of the day, my lord, they had been in a fiduciary relationship, my lord, husband and wife, my lord. The reasonable explanation should have been there from the accused, my lord. But even if that is ignored, my lord, then the prosecution has failed to prove the case beyond reasonable doubt in view of the fact that, my lord, even the material exhibits, the branch of tree, the bamboo and the clothes were never sent for forensic analysis, my lord. So, my lord, those also do not directly pinpoint the accused for the commission of offense, my lord. And my lord, the assault, lastly, my lord, the assault which has been shown in the postmortem report, my lord, if there are no such strained relationship between a husband and wife, my lord, those cannot be imputed, my lord, by the husband, my lord. Such brutal, my lord. Because if they have sudden scuffle or over anything, my lord, he would have directly smashed on the head and she would have been killed, my lord. But that brutal, my lord, something is there. This is my humble. I'm obliged, your lordship, for giving a patient hearing.
We will hear you at 2:59.
Couple with the lordship, the weapon.
You're saying extrajudicial confession
Yes,
to
to PW1, my lord,
Mm,
PW2,
mm.
PW3, and PW4. And your lordship, PW1, who happens to be the next neighbor, your lordship, she heard the shouting part, your lordship, on the date of occurrence, my
She says her house is located about 1 kilometer away.
away, but she stays 1 kilometer away, but she said it was night and she heard the shouting, my.
Can you hear something from 1 kilometer away?
It's a prosecution version, your lordship, I have to rely on it. And apart from that, your lordship, before PW4, extrajudicial confession coupled with the accused person showed the stick by which it was assaulted, my lord. So, your lordship, if your lordship can rely on the evidence of these two witnesses, your lordship may affirm the conviction. May I take your lordship to the evidence of PW1 first, my lord?
Yes.
Sushmita Kishko. Eight.
Yes.
I know Baska, the accused, on 13/3/17, the incident occurred at 11 p.m. The accused killed Helena Kishko at night. He assaulted his wife to kill him. I heard shouting on assaulting her to kill her. He assaulted Helena by stick. The stick bamboo used to kill Helena by accused. I saw lying the dead body. Whole body was wounded due to assault. So the occurrence had taken place at 11 p.m., Your Lordship, at the date night at 11 p.m., my Lord. Generally, there is no sound at that hour, Your Lordship. Silence takes place, my Lord. So there might be a possibility that she hears even if her residence is she resided at 1 kilometer away, my Lord. There's a possibility that she heard the sound. In a cross-examination, I reside nearer to the accused. The distance is 1 kilometer in between our residence. I was at my residence on 13/3/17 at the time of incident. It's not a fact that I did not hear the shouting at the time of assaulting Helena by the accused. Police recorded my statement. I said the incident to police. It's not a fact that I did it as FIR, and a statement to police. I heard sound. I did not see the incident. It's not that a fact that I did not say I'm bleeding to police. I did not inform other at night as I was alone at night at my residence. The accused confessed guilt. It's not a fact that the accused was outside on the day of the incident. It's not a fact that victim was killed by others. The villagers were present confessing the guilt. Sanjay Mardi, Labdi Mardi, and Lakki Ram Sarayan was available at the time of confessing the guilt. The villagers handed over him to police. The accused used stick to kill Helena. The bamboo sticks were available in everyone's house. So now the evidence before my Lord, PW2, before whom also extrajudicial confession was made, my Lord. At page 10. I know the accused. I know the informant. Susmita's sister, the victim's my sister-in-law. The incident occurred 6 months ago. The night the incident occurred, the accused killed Helena at night. The accused confessed guilt before me. So there was extrajudicial confession before him also, my Lord. So here there is no confrontation, the cross-examination about the extrajudicial confession. So it remained admissible. Police did not ask me about the incident. Police took my signature. I don't know why the police took my signature. Then before my Lord, PW 3, my Lord. Roger Tudu. I know the accused. I know the informant. This is my sister. The incident occurred at night on the day of Holi. The accused confessed to me he killed his wife. I saw the dead body of Helena at morning. So the accused killed Helena by bamboo stick. Then in cross, my Lord. I did not say about killing Helena by Baska to police. Police took signature of me on a paper. I don't know the reason of taking signature to me. Then Your Lordship, before PW, my Lord, 4, my Lord. There was also extrajudicial confession, my Lord. I know the informant. I know the accused. The incident occurred on the day of Holi. The accused committed the offense of murder. Baska killed his wife Helena at night. I visited the residence of accused. The victim was lying dead in injuries of all her body. The accused killed Helena, confessed before us. He showed us the stick of killing Helena. I did not see killing Helena. It's not a fact that Baska did not confess before me that he killed Helena. It's not a fact that I deposed falsely today. So, Lordship, and there was, Your Lordship, that the crime weapon that was recovered was seized by the police, my Lord. But I have checked the 161 statement, that disclosure statement or something. I did not find it, my Lord. That accused showed the weapon. But they said, my Lord, there's a note of the police, IO. They said it was lying there, so they seized it. So, Your Lordship, now I take Your Lordship to the evidence of PW6, who is the doctor. The opinion of the doctor at page 18, my Lord.
Yes.
So their injuries, Lordship, Your Lordship will take into account. As an average built female dead body, approximately 40 years, examined rigor mortis present, clotted blood seen in both lower limbs and clothes, bruises seen multiple in number in both upper limb and lower limb and back of the chest, multiple tear of anal canal and clotted blood following perforating injury. There is complete fracture of right upper end of humerus bone, collection of blood around the soft tissue. In my opinion, the cause of death is neurogenic shock and hemorrhage following hit by a blunt weapon by a high velocity, which is antemortem in nature. And the time since date is 12 to 16 hours, my lord. And the weapon use, although lordship, there was a procedural irregularity, but the weapon use was a lordship is a broken wooden branch, my lord. And the velocity as and lordship, as per the opinion of the doctor, my lord, with high velocity, the deceased was hit, my lord. And the contention of a learned friend is that there is a defect in investigation, a defect in lordship, and material witnesses were not examined, and non-sending the crime weapon to FS, and whether it is fatal to the prosecution case or not. That aspect your lordship will take into account, my lord. And how far the evidence of the witnesses before whom the extrajudicial confession is made, how far it is reliable. On that ground, may I cite certain judgments of this honorable court, your lordship, as reported in 2010, 2 SCC 583,
2 SCC.
583. Para 52 and 53.
Yes.
Though extrajudicial confession is considered to be a weak piece of evidence by the courts, this court finds that there is neither any rule of law nor of prudence that the evidence furnishing extrajudicial confession cannot be relied upon unless corroborated by some other credible evidence. The evidence relating to extrajudicial confession can be acted upon if the evidence about extrajudicial confession comes from the mouth of a witness who appears to be unbiased and in respect of whom even remotely nothing is brought out which may tend to indicate that he may have a motive or attributing an untruthful statement to the accused. Para 53, in state of UP versus MK Anthony, this court, while explaining the law relating to extrajudicial confession, ruled that if the words spoken by the witness are clear, unambiguous, and unmistakable, one showing that the accused is the perpetrator of the crime and nothing is omitted by the witness which may militate against it, then after subjecting the evidence of the witness to a rigorous test on the touchstone of credibility, the extrajudicial confession can be accepted and can be the basis of conviction. According to this court, in such a situation, to go in search of corroboration itself tends to cause a shadow of doubt over the evidence, and if the evidence of extrajudicial confession is reliable, trustworthy, and beyond reproaching, the same can be relied upon and a conviction can be found thereon. So, your lordship, in the instant case, the evidence of these witnesses, my lord, more particularly PW, my lord, 2, 3, and 4 are reliable and cogent, so their evidence can be accepted. Then one more judgment on extrajudicial confession, minor 2012. Six SCC
2000.
12 6 SCC 403. Para 14.
Yes.
Para 14. It is a settled principle of criminal jurisprudence that extrajudicial confession is a weak piece of evidence. Wherever the court, upon due appreciation of the entire prosecution evidence, intends to base the conviction on an extrajudicial confession, it must ensure that the same inspires confidence and is corroborated by other prosecution evidence. If, however, the extrajudicial confession suffers from material discrepancies or inherent improbabilities and does not appear to be chosen as per the prosecution version, it may be difficult for the court to base a conviction on such a confession. In such circumstances, the court would be fully justified in ruling such evidence out of consideration. Now, we may examine some judgments of this court dealing with this aspect. In Balwinder Singh versus State of Punjab, this court stated that principle that an extrajudicial confession by its very nature is rather a weak type of evidence and requires appreciation with a great deal of care and caution. Where an extrajudicial confession is surrounded by suspicious circumstances, its credibility becomes doubtful and it loses its importance. In Pakirish Swami versus State of TN, it is held that it is well settled that it is a rule of caution where the court would generally look for an independent, reliable corroboration before placing any reliance upon extrajudicial confession. Again, in Kavita versus the State of Tamil Nadu, the court stated that dictum that there is no doubt that convictions can be based on extrajudicial confession, but it is well settled that in the very nature of things, it is a weak piece of evidence. It is to be proved just like any other fact. The value thereof depends upon the veracity of the witnesses to whom it is made. While explaining the dimensions of the principles governing the admissibility and evidentiary value of an extrajudicial confession, this court in State of Rajasthan versus Rajaram stated the principle that an extrajudicial confession, if voluntary and true and made in a fit state of mind, can be relied upon by the court. The confession will have to be proved like any other fact. The value of the evidence as to confession, like any other evidence, depends upon the veracity of the witness to whom it has been made. The court further expressed the view that such a confession can be relied upon and conviction can be founded thereon if the evidence about the confessions comes from the mouth of witnesses who appear to be unbiased, not even remotely inimical to the accused, and in respect to whom nothing is brought out which may tend to indicate that he may have a motive of attributing an untruthful statement to the accused. In Aloknath Datta versus State of the West Bengal, I have just cited before this judgment, my lord. The court, while dealing the placing of reliance on extrajudicial confession by the lower courts in absence of other corroborative matters is unjustified, observe, confession ordinarily is admissible in evidence. It is a relevant fact. It can be acted upon. Confession may, under certain circumstances, is subject to law laid down by the superior judiciary from time to time, form the basis of conviction. It is, however, tried that for the said purpose, the court has to satisfy itself in regard to voluntariness of the confession, truthfulness of the confession, and corroboration. A detailed confession, which should otherwise be within the spatial knowledge of the accused, may itself be not sufficient to raise a presumption that confession is a truthful one. Main features of a confession are required to be verified. If it is not done, no conviction can be based only on the sole basis thereof. Accepting the admissibility of the extrajudicial confession, the court in Sansarsam versus State of Rajasthan held that there is no absolute rule that an extrajudicial confession can never be the basis of a conviction. Although ordinarily an extrajudicial confession should be corroborated by some other material, certain citations are given. The present phrase, the extrajudicial confession by Balwan, has been referred to in the judgment by the learned magistrate and a special judge, and it has been corroborated by the other material on record. We are satisfied that the confession was voluntary, was not the result of inducement, threat, or promise as contemplated by the Section 24 of the Evidence Act. Dealing with the situation of retraction from the extrajudicial confession, we don't require that, my lord. In para 15.8, extrajudicial confession must be established to be true and made voluntarily and in a fit state of mind. The words of the witnesses must be clear, unambiguous, and should clearly convey that the accused is the perpetrator of the crime. The extrajudicial confession can be accepted and can be the basis of conviction if it passes the test of credibility. The extrajudicial confession should inspire inspire confidence, and the court should find out whether there are other causes circumstances on record to support. Then your lordship, regarding defect in the investigation, may I cite 2007-11 SCC 195. Yeah, no. Lordship, I could not give the citation. I'll just read out slowly, my lord. I'll give the citation later. 2017-11 SCC 195. Para 30.
Yes.
In C. Muniappan versus State of Tamil Nadu, this court explained the law on this point in the following manner. There may be highly defective investigation in a case. However, it is to be examined as to whether there is any lapse by the IO and whether due to such lapse any benefit should be given to the accused. The law on this issue is well settled that the defect in the investigation by itself cannot be a ground for acquittal. If primacy is given to such design or negligent investigation or to the omission or lapses by perfunctory investigation, the faith and confidence of the people in the criminal justice administration would be eroded. Where there has been negligence on the part of the investigating agency or omissions, etc., which resulted in defective investigation, there is a legal obligation on the part of the court to examine the prosecution evidence, dehaul such lapses carefully to find out whether the said evidence is reliable or not, and to what extent it is reliable, and as to whether such lapses affected the object of finding out the truth. Therefore, the investigation is not the solitary area of judicial scrutiny in a criminal trial. The conclusion of the trial in the case cannot be allowed to depend solely on the probity of investigation. Then regarding lordship, my learned friend has made a submission that they are related to the victim, the witnesses. Lordship 2008-11 SCC 722. Para 49, no? Para 49, 59. Lordship, the citations that Nitin did not give. I'm sorry, Lordship, I'll give the citations later or get it xerox. Para 49. It is by now well settled that the mere relationship of the witnesses cannot be the sole basis to discard or disbelieve their evidence if it is otherwise found to be believable and trustworthy. However, when the court has to appreciate the evidence of an interested witness, it has to be very careful in weighing their evidence. In other words, the evidence of an interested witness requires greater care and caution while scrutinizing his evidence. The court has to address to itself whether there are any infirmities in the evidence of such a witness, whether evidence is reliable and trustworthy, and whether the genesis of the crime unfolded by such an incident is probable or not. If the evidence of any interested witnesses or relative on careful scrutiny is found to be consistent and trustworthy, free from infirmities or any embellishment, there is no reason not to place reliance on the same. Then para 50, in Mehraj Singh versus State of UP, this court held that testimony of interested witness cannot be rejected on the sole ground of interestedness, but should be subjected to close scrutiny. And one more factor, Your Lordship, the accused person is found inside his residence. He was there, Your Lordship. There's no, although he has taken the plea of alibi, but he could not substantiate that plea, Your Lordship, by way of bringing witnesses, my lord. There's nothing on record, my lord. And Your Lordship will only note the time, and the time of occurrence is 11 p.m. There's no explanation. that he was not there. Although he said he was not there, but he could not substantiate that plea, my lord. So my respectful submission is that the learned court below has rightly upheld the judgment. But your lordship will reappreciate and appreciate the evidences on record once again. In appellate stage also, your lordship, to uphold the conviction. That is my request.
Give the copy of the judgment.
I'll give.
My lord, I have only limited reply to make. My limited reply would be purely based on the statements on record, my lord. If your lordships kindly see page 10, my lord. Initially, my lord, I'll take your lordship to page 9, my lord. Page 9. Page 9, my lord. My lord, 7 line from the top, my lord. It is not a fact that victim was killed by others. The villagers were present at the time of guilt. Sanjay Mardi, Lavdi Mardi, Lokis Ram Soren was available at the time of confessing the guilt. So, my lord, the very first thing comes is that the accused has made confession before certain peoples. Now, they say that not before the police, but before certain peoples. Now, these 3 persons were not there before the court. Not a single person being a witness to the entire case, my lord. First reply, my lord.
Yes.
Second part, my lord, page 10, PW2. The interested witness, because he being a relative, my lord, page 10. Now, lordship would find the third line. The accused confessed guilt before me. Me means not before the police, before them. But otherwise, the PW, the informant, PW1, the sister says that he was not present because the other 3 were present, who were not being the witness in this case, my lord.
No, it says villagers were present. So maybe these 3 persons were there also along with the PW 2, 3.
My lord, that is why at page 9, I have specifically read out the villagers were present at the confession of the guilt. Sanjay Mardi, Labi Mardi, Lokhiram Soren was available at the time of confession. She has specifically named the persons. She never says that except and others were also present. This part is missing. This part is missing, my lord. Had that been the place, my lord, had that been the course, my lord, I would have taken your lordship words, my lord. But she never says others were there. She has stated 3 persons' name. This is the informant's, my lord, cross-examination. She says 3 persons, my lord, but she never says that and others were there. Had that been others, my lord, I could have taken, my lord. Now, my lord, before me is this at page 10 also, PW2. Now, PW3 also, if your lordship sees as page number 12, my lord. Second line, the accused confessed to me he killed his wife. Now, again, he speaks to himself only. But these 2 witnesses, 2 and 3, never says that others were also present there. But that part, they are not agitating in their evidence that others were also present. And my lord, they themselves has shown their relation to. Now, my lord, the decision which my learned senior colleague has placed before this honorable court, the initial word starts with extrajudicial conviction is a weak piece of evidence, and that has to be corroborated by the materials available on record. Now, lordship would kindly turn to page 19. Page 19, my lord, for a moment. This is the statement of the IO, my lord. In the entire, I'll just read out I'll be just giving a trouble to your lordship. The entire statement never says that, the IO never says that he made confessions before the villagers. This part is entirely missing from the evidence, my lord. I'll read out. On 14, I was working as in charge of so-and-so. On that day at around 9:30, once Susmita came to our OP and informed that her sister has been killed by accused. Accordingly, informing the so-and-so, I visited the place of occurrence along with my staff on so-and-so. When I reached the house of the accused, I saw the dead body of so-and-so in the house of the accused. He was also present at that time. Accordingly, I apprehended the accused, drawn a sketch map, and recorded a statement of witnesses. As Exhibit 3 is the sketch map and Exhibit 3.1 is my signature. Inquest of the dead body was done by the magistrate and thereafter I sent the dead body for PM. After completion of the investigation and collecting the PM report, I also filed the charge sheet against the accused Barkha Murmu under so-and-so section. In the charge sheet, is Exhibit 4 is charge sheet, Exhibit 4 is my signature. During the investigation, I seized one broken branch of a tree and one bamboo lathi with blood stain and also seized one piece of cloth. Exhibit 2 is the seizure list. Exhibit 2.3 is my signature. I saw the seized articles in the court today. So-and-so, so-and-so. This is the chief, my lord. Now cross. Most part of the investigation was done on the basis of the GD entry. I also recorded a statement of witness on the basis of GD. I have not furnished the extract copy of the GD along with the charge sheet. I seized the item from the place of occurrence, which was shown by the accused, but not from the possession of the accused. Now, my lord, the learned senior counsel has also made one submission before this court that there was not a disclosure statement from the accused that, or either from the police, that he took to the place where from the weapons were seized or the materials were seized, by which it has been stated that the deceased was assaulted, my lord. I also seized one piece of cloth, so-and-so place of occurrence, but I have not sent it for reference. The house of the informant is about half kilometer from the house of the accused. It is not a fact that the accused did not kill his wife Helena. The accused is confessed before me, but I have not. So, my lord, at one point, the prosecution says that the extrajudicial confession was made before the police. At other point, they say that, my lord, the extrajudicial confession was made before certain witnesses, my lord. And the informant who comes before the court never says that that was done. None of the witnesses says that the others have heard the shouting at night. Because if I say that my place was in an isolated place, my lord, but Helena, the Susmita, the PW1 or the other witness never says that they were not residing together. If one person could have heard the sound, the others could have also heard. Now, second part is that by morning, everybody has seen them. But at night, nobody has seen myself there. And my lord, at the time of starting my argument, I've said that it was a day of Holi, my lord. People generally take too much of, my lord, alcohol and they don't know where they are. So morning, while he came to his place of residence, there were people, he was also shocked. He might not make, he could not understand what has been happening, my lord. In that part, immediately he was handed over to the police. But as far as this extrajudicial confessions are there, my lord, some says that before them, police says before me, but police never says that the extrajudicial confession has come from the witnesses also, because he records the statement. And even 2 and 3, lordship would find that they say that police did not even ask me a particular question. Then how come they became a witness? Only because in the seizure list, their signatures were there, my lord. That is why, my lord, they turned up to the court and they improved their statement being the interested witness, my lord. Otherwise, my lord, kindly see the cross again, once again, my lord, at page 10, my lord. This is PW2. Page 11, sorry, my lord, page 11, PW2. Police did not ask me about the incident. Police took my signature. I don't know why police took my signature. So how can their statements be relied by the honorable court, my lord, once they say that I have not made any statement? But since, my lord, that is why at the initial, my lord, I took your lordship to the seizure list because these 2 and 3 are the seizure witness. For that only. But they did not make any statement before the IO, my lord. So, my lord, the prosecution story of making an extrajudicial confession, my lord, is not there, my lord. And nobody states that at night I was there, my lord. So that part, my lord. And the informant also never says that apart from these people, some others were present there, my lord. And why those independent witnesses were not brought to record, my lord. And even, my lord, the Honorable Learned Trial Court has power under 319 subsection 2, my lord. During evidence, if the court finds that these persons are accused or that their evidences are required, my lord, the court can call. But even court witnesses will be brought up, my lord. So those procedures were always available, my lord. But the prosecution evidence was short of that, my lord. Only since I could not make a, my lord, plausible explanation that where I was, my lord. That does not bring me within the preview of being an accused, my lord, for killing my wife, my lord. There were 3 minor sons, my lord. Even otherwise, my lord, in POSCO cases or other cases, your lordship would find that the learned trial court are taking the examinations, my lord. On the strength of that, my lord, the peoples are convicted, my lord. They might not be able to speak out in a difficult term, but when in an easier term, they can say that there was a scuffle between my mom and dad. Or something they could have said, my lord. Even nobody says that they heard that there was a scuffle at night, my lord, between the husband and wife. And even the informant PW1 never says that I heard the shouting of this accused person. So these things are not there on record, my lord. So, my lord, extrajudicial confession will not come, and the interested witness which they have stated, my lord, their evidence are not that clear enough to put me behind the bars, my lord. And since the, my lord, since the day of the incident, my lord, I'm there in jail, my lord. So already, my lord, it has been long, my lord. Let's see, my lord, from the charge sheet, from the FIR, my lord, page 3. Since 2017, my lord, this person is behind the bar. 15/3/17, my lord. Because on 14/3, he was arrested, my lord. The FIR was registered on 15/3, because prior to that, my lord, the GD entry was, on the strength of the GD entry, only the investigation was carried out, because on the strength of the FIR, the investigation was never taken up. That is why, my lord, the re-examination of the IO was taken, my lord. Somebody has been killed. That improvisation was the FIR, my lord. Because FIR is not the GD entry, my lord. FIR is not the GD entry.
Okay.
This is my submission. I'm obliged, your lordship.
But Mr. Atal Tiwari,
Atal Tiwari, my
learned amicus curiae of the heart amendment. Additional to the hearing concluded. Just 1 minute.
deeply obliged, your lordship.
Here, what had happened is, your lordship will remember on the last occasion, lordship was sitting with Justice Ete, and Justice Ete wanted us to find out one decision, which was passed recently by the Honorable Supreme
Yes,
Court,
yes.
saying that in case of juvenile, the conviction will stay, but the sentence will go. But that is not disputed. In fact, here is a case where the juvenility aspect has not been gone into. That issue is yet to be determined. Of course, what he has filed one IA saying that he is juvenile, and he has annexed 2 certificates showing that there are 2 accused, showing that both were around 17, 18 at the time of occurrence. But in the 313 statement, what I see is they were around 32, 33 years. But then, yes, he has annexed 1 school certificate and 1 certificate by the Gampura saying that They were born 99 and 2000. Occurrence was in 2017. So they were around 17, 18 at the time of occurrence. So, Lordship, what I would pray is that Honorable Supreme Court has said that if your Lordship is prima facie satisfied on the documents placed by the parties that the accused could be juvenile, then the Lordship can call for a report from the district judge under the Juvenile Justice Act, Section 95.
So Lordship, at page 8 and 9.
You are.
Yes, my lord. The applicant number 1, he was 16 years and 5 months old. And the applicant number 2, he was 17 years and 6 months old on the date of occurrence.
Yes, is this in my the earlier file?
This is a POXO matter, Lordship, will not require, I think. Now, Lordship is not going into the merit of the case, no, about the live streaming.
I'm not going to the limit.
And
I'm not claiming promotion on the basis of the draft rules. I am claiming promotion on the basis of a law laid down by the Honorable Supreme Court. That if there is a past practice being followed, that has to be followed.
Yes,
Admit-
Chalia.
Lordship, here, Lordship, Mr. B. Gogoi, he's on legs, my lord. But the affidavit has been filed, Lordship.
That I've seen.
Yes,
Practically, there's nothing in the affidavit.
Lord, that clarification, Lordship, can be given by my senior. He's on legs, my lord, in court number 4. He'll come directly over here. Lordship,
My only prayer before this Lordship is that this case is languishing since last 4 or 5 years. That is not the great issue. The issue is that they say the draft rules has been sent to the finance department, personnel department only in 23. That shows their approach. And if your Lordship disposes on that line, this will not be done in the next 10 years. So your Lordship may decide the case on the merits instead of going by that, your Lordship.
that can
Either your Lordship allows the case or your Lordship dismisses the case. But I have demonstrated before your Lordship that the Honorable Supreme Court has time and again said that the long-standing practice will follow. This is an admitted fact that they have been promoting. There is no service rules. There is no service rules in the entire health department, your Lordship. So this practice is going since inception, your Lordship. It is not the first case. So there cannot be any hindrance.
Who's appearing?
Lordship, Mr. B. Gogoi, Lordship. He's on legs in court number 4, Lordship.
Till then, I may make my submission, your Lordship has heard the matter at length, your Lordship.
I've forgotten more.
But I can just refresh it.
We can. Supposing if he does not come again, how long will it take?
Lordship, the NHM matter, Lordship, it's been going on for the last 15 minutes, Lordship. So, sometime, Lordship, if my learned friend agrees, Lordship, a date can be fixed immediately after Bihu break, and Lordship can hear the entire argument at length, my Lordship.
Your Lordship will always be on legs. He's a busy advocate. But the thing is that this
No,
matter has to
one
be
thing
decided.
is this, I can do what you are suggesting.
Lordship.
But the thing is, issue is, we can't keep a matter partnered for such a long period. Number 2 is, on the date fixed, if he's not there again, that will be the big issue.
Lordship may record that, and Lordship will appear, Lordship. It's only because he's on legs, my Lord. That is the only difficulty.
Otherwise, you can make some alternative arrangements also.
Lordship, that can be done. But
He is competent. Let me make my submission. If he comes well and good. Otherwise,
If I hear you again, he does not.
if your Lordship is sitting on 19, if your Lordship, I don't know, if your Lordship is sitting on in the next week, then
I'm sitting.
then I can start today, your Lordship. I can refresh it. 19th, let him come and make his submission, your Lordship.
within the
No further-
the Bihu break will come in between, Lordship. If
No
Lordship,
issue to that effect, your Lordship. This is already parted matter. They are trying to delay the matter. That's it.
Lordship, we are not delaying the matter. Lordship, we were supposed to file the affidavit on the last date. We have.
And what affidavit they have filed, we have seen it, your lordship.
Lordship,
He did
that
not make
justification
submission on
will be
that.
given by my senior lordship. I'm not in a position to argue on that.
Then let him take his seat, your lordship.
Then, Mr. Sinha, we'll fix it on 19th. then.
Your lordship, the same issue would come up again, your lordship.
No,
Lordship may record it, Lordship. One last opportunity.
Because my case is very simple, your lordship. Either your lordship will hear, allow me to make my submission, you take, you are not debating. Take your seat, please.
Yes, continue.
Your lordship, the issue is like this. I am making my submission on the basis of a law point which squarely covers my case.
No, I've got your point. I've got your point. on-
Nothing more, nothing less. So if
You
your
are
lordship is
saying
satisfied,
that in the past, this thing was going on, that promotion was being given from this particular post
yes,
to that particular post.
till 2008.
And then there are no service rule present in the,
Right, your lordship.
so far as the present, as far as the petitioner's post is concerned.
Yes, your lordship.
So therefore, they should continue doing what they were doing before.
Right,
Practically, that's your whole issue.
right, your lordship.
Now, I want to hear what the other side says. That's all.
Your lordship,
Maximum, I can give you 5-10 minutes.
right.
After that, I've got all of it.
Your lordship, this practice went till 2008.
I know.
In 2010, we have been appointed. Thereafter, the occasion did not arise rather, I would say, to promote. Because after that, there was no more further assistant entomologist. We three have been appointed 2010. Prior to that, all assistant entomologists have been promoted. It is only when it came to our case, they have stopped there. They are not acting on the same.
Lordship, he's on his way.
Okay. Proceed.
Your lordship will kindly look at page 23. This is my mark sheet of BSc. Now the requirement, as is admitted, your lordship, the requirement to be appointed as assistant entomologist is BSc with zoology as one of the subject. It might be major, it might be past course.
Affidavit book কি হলো? আরো এখন affidavit না কেন?
Your lordship, this is the mark sheet which shows general subject. If your lordship has got the middle portion, general subject, chemistry and zoology, ZOO, it's written there in page 23. So all these petitioners have zoology as their one of the subjects, which I've annexed. Now pursuant to that, there was an advertisement. These appointments were made pursuant to a valid selection process. There was an advertisement, we participated, we got selected. Now our appointments orders are at page 28.
Where is your advertisement?
Your lordship, the advertisement I don't have because I could not annex it, but there is no dispute to my appointment, your lordship. Your lordship will look at page 28. I'll just read one of the appointment letter. In persons to government approval white letters number dated 21/2006 and HLA dated such and such, and subject to discharge without notice and without assigning any reason thereof, and in anticipation of receipt of satisfactory PVR, that is police verification report. The following person is appointed as assistant entomologist again the vacant post under the Directorate of Health Services, Assam, temporarily in the scale pay of such and such, plus other allowances. The appointment will be governed by the new pension rule by such and such. Now, I'll not bother your lordship with all those things. I'll straightway take your lordship to it was on. Page 31. Page 31, your lordship. We have undergone the 10 days hands program. This is certified that Mr. Midul Talukdar, assistant entomologist, Jonal such and such, Guwahati, underwent and completed 10 days hands-on training at these centers on various relevant entomological techniques related to different mosquito-borne diseases under the ambit of NVBDCP. That is National Vector-Borne Diseases, including identification of mosquito field collections. And this is a certificate which has been issued to us. Page 32. 33 and 34 are the certificates that were issued to these persons who have undergone the training. After our appointment, we need to undergo the training. So these are the training certificates been allotted to us, issued to us That is from page 31 to 37, your lordship. Now, as there was a long-standing practice of promoting the assistant entomologist to the cadre of district malaria officers, so we made an application. The issue was, the criteria was with qualification as BSc Zoology as one of the subject and 5 years of service in the feeder cadre of assistant entomologist. So we made an application to the director, he being our authority. Although these posts are gazetted posts, the appointment has to be made by the government. So we made an application to the director. The director forwarded it to the joint director, and accordingly, the ACRs were sought. If I may just read it out. With reference to the letter number quoted above, I am to request you to kindly forward here with the list of assistant entomologists under the state along with the vacancy position of DMO and ACR of the last 5 years of the for favor of assistant entomologist against each vacancy according to their seniority immediately. You are requested to submit in prescribed A. Your lordship, this format is sought only when a promotional exercise is supposed to be carried out by the department. Otherwise, it is not sought, your lordship. The ACS remains there. Now, your lordship sees our ACS have been forwarded, page 40, annexure 5. The joint director forwards it to the ACS, to the director. The ACS, our ACS, which has been sought. With reference to the DHS letter on subject cited above, I have the honor to submit here with the ACS of the 3 numbers of assistant entomologist. Page 40, your lordship. Has your lordship got it?
Yeah.
With reference to the DHS letter on subject quoted above, I have the honor to submit here with the ACRs of 3 numbers of assistant entomologists in original as desired by you. There are only 3 assistant entomologists there before this honorable court, your lordship. Now, your lordship will turn to page 41. These ACRs were forwarded to the government from director to the secretary government of some health department. I may read it, your lordship. With reference to the subject cited above, I have the honor to enclose here with the gradation list along with the ACRs of the following entomologists under the Joint Director of Health Services, Malaria cum State Program Officer such and such for the year 2012 to 17. In connection with the proposal for filling up the vacant post of district malaria officers, he categorically mentions it, your lordship. By way of promotion from the post of assistant entomologist to district malaria officer, as per the minutes of the meeting of the selection committee for promotion, it was decided to fill up the vacancies of the district malaria officer for assistant entomologist by way of promotion in the ratio of 2:3. That is 2 by direct recruitment and 3 by means of promotion from assistant entomologist who have completed 5 years of services provides other general criteria for promotions are fulfilled. In such way, based on the minutes, 2 assistant entomology was promoted to DMO in 1997. So, your lordship, this is very categorically stated that there were some communications which was sought from the director as regard the ACS for a promotion exercise which was supposed to be undertaken to the cadre of DMO from the assistant entomologist, your lordship. Now, your lordship turns to page 44. Now, the promotional exercises started somewhere, your lordship. They have been denying that we have not carried out anything. This reflects that they have been making a blatant lie before this honorable court. Page 44, Annexure 7. Has your lordship got it? This is from the deputy secretary. He writes to the director now. With reference to the subject cited above, I am directed to request you to furnish the following information to this department for promotion of assistant entomologist to district malaria at an early rate. Now, your lordship, why this letter has been written? If they have not carried out any promotional exercise or they are not trying to carry out any promotional exercise, why this government is writing to the director and he seeks for this up-to-date vacancy position of DMO, up-to-date ACR last 5 years in respect of assistant entomologist, up-to-date APR of assistant entomologist, gradation list, merit list. Now 6, furnish copies of the qualification of the candidates eligible for promotion along with certificates of assistant entomology training. The minutes of the selection committee meeting dated 29/5/1997 is enclosed for reference in respect of eligibility criteria and others. Your lordship will turn to page 54 straightway now. Annexure 12. This is the minutes of the meeting based on which the promotion exercises was carried out to the cadre of DMO from assistant entomologist. And this minutes finds a reflection in the letter written by the government to the director. That was at page 44. I've just read it now, Your Lordship. May I read it? Minutes of the meeting of the selection committee for promotion to the rank of district malaria officer from the cadre of assistant entomologist held on 29/5/1997 at 11 a.m. in the office chamber of Commissioner and Secretary, Health, Family Welfare Department. There was a chairman was the commissioner and the health secretary. Additional secretary was the member. Director of Health Services was the member, and joint secretary personnel department was member. Your Lordship, the highest level of the officers in the health department constituted this committee, including the joint secretary from the personnel department. It means it was a unanimous decision, Your Lordship. The selection committee was informed by the member secretary that there is no service rules, service order, etc. Your Lordship, I'll pause there for a moment. It means that this system was being followed prior to this, Your Lordship, because they say the selection committee was informed by the member secretary that there is no service rules, etc. in matters relating to service conditions of various cadres post under NMEP, that is National Malaria Eradication Program organization. However, it was been decided to fill up the vacant post. It has been decided to fill up the vacant post of district malaria officers, keeping in the ratio 2:3 by direct recruitment and by promotion. Total sanction strength of DMO is 17 numbers. To maintain 2:3 ratio, 17 posts should be filled up by direct recruitment and rest 10 posts should be filled up by a promotion from amongst the cadre of assistant entomologists in order to give more promotional avenue to the existing incumbents. As per records, 8 numbers of posts of DMO have already been filled up by direct recruitment, while 7 numbers of posts of DMO have been filled up by promotion. As such, direct recruitment exceeded by 1 post. The selection committee has suggested to adjust the said 1 post against future vacancy. Now they speak of eligibility criteria. For direct recruitment through APSC, a candidate must be BSc with Zoology as one of the subjects. For promotion, a candidate must be BSc with Zoology and advanced entomology training, having at least 5 years of regular service as assistant entomologist. We were appointed in 2010. It is 2023. 13 years of service. We have BSc with Zoology as one of the subjects and the advanced training certificate we have with us. In spite of that, we have not been considered. Now your Lordship will look at page 50. Why I jumped to page 54 from 44? Because of page 44 was the letter which was written by the government to the director, making a reference of this minutes. So government is very much aware of this, and they have been carrying out this promotional exercise based on this minutes, Your Lordship. So page 50, Your Lordship, it is a promotion. May I just read, though 4D, Your Lordship, but they have been regularized later on. Your Lordship has put a query on the last to last occasion to my learned friend when this matter was being heard, that with what has happened to these persons. Now, I don't know whether he has produced it or not. He has not said anything to this. He has not denied it. Although he has not admitted it, but he has not denied it, which means the fact stands correct as on date. As per my instruction, these persons have retired also from that post. Maybe in 4D, but these persons were promoted in terms of that notification or the administrative order instruction, whatever they say. On the recommendation of the selection committee and subject to the reversion without notice and without assigning any reason thereof, following assistant entomologist and NMEP are temporarily promoted to the post of district malaria officer under regulation 4D of APSC for a period of 1 year. On promotion, Chandra Sen Pegu, then on promotion, Fanidhar Hira, on promotion, Ravindranath Talukdar, Tankeshwar Datta. These persons are promoted. Then your Lordship will come to page 53. No, not 53. Then your Lordship will come to page 56. Again, 2 persons have been promoted, Your Lordship. Nandaram Chaudhary and Kandarpo Kumar Pathak. This is in 2001. Then page 59, Your Lordship. On recommendation of the selection committee, there was a selection committee, and subject to reversion without notice and without assigning any reason, Deepak Tamali, assistant entomologist under NMEP, is temporarily promoted to the district malaria officer. This was the last promotion that has taken place to my instruction, and it is way back in 2008. So your Lordship has in 2008, in 2001, as well as in 1997, 1993. So since 1993 to 2008, that is a period of 25 years, they have followed this practice. In 2010, we were appointed, Your Lordship. So we are the only three, these three petitioners are the only three assistant entomologists left out in the entire cadre. So my friend has been repeatedly saying that no promotion has been taken place thereafter. You could not have done that because we are the three who have been left out. Now, page 60 is the educational qualification, Your Lordship, but there is no dispute to that. It is admitted fact that the qualification required is BSc Zoology as one of the subject. Now, page 62, Your Lordship. These are the persons as on that date holding the post of DMO. And petition and number 11 to number 19 are all 3F appointee.
What is it?
That is regulation 3F. They are temporarily appointed. They have no right to that post, in fact. And as on date, there are 19 vacant posts, Your Lordship. These three persons can be easily accommodated. That is clearly reflected from the affidavit they have filed, Your Lordship. Now, one judgment I have given on last occasion. The Lordship has one judgment out there. I suppose I given it last occasion. Nagpur Improvement Trust, 1999 8 SCC. Has your Lordship got it? Your Lordship, I'll just, before I take your Lordship to the facts of this case, I'll just present the brief story of this case. Has your Lordship got the judgment?
No.
1999 8 SCC, I say.
You have a spare copy?
I'll give my copy, Your Lordship. No issue. Hmm? 1999 8 SCC. Okay, details and all. Dada. तो कॉपी क्यों ना रखना? Huh? No. Your Lordship, paragraph 2, 3, and 10, Your Lordship. There was a case, what happened? Nagpur Improvement Trust. There was an act. They don't have any rules. Now, the Nagpur Improvement Trust, they have issued an advertisement. They are giving a go by as regards the, as there was no rules to follow. Now, they have framed, they have issued an advertisement. Paragraph 2, 5, and 10, Your Lordship. Now, they have issued an advertisement. Now, the private respondent, they go before the Bombay High Court, saying that this advertisement has been issued without any rules being framed thereafter. Now the matters goes up before the Supreme Court. Now the Supreme Court has observed that in para 10, that this has been a long-standing practice. There is no rules. Admittedly, there is no rules in the department. Just like in the health department, there is no rules, as they have already said. There was also no rules, Your Lordship. If Your Lordship reads para 10, that will make the things very clear. There was no rules. And the Supreme Court said it has been long-standing practice. And they are the ones who has to make the appointment. The post cannot be kept vacant. And as such, although the Supreme Court has said that they can go ahead and frame the rules, but plea taken by them, the private respondent, that there is no rules and therefore these appointments could not have been made, is not tenable in the eye of law, because that has been long-standing practice and that has to be followed. So I have based my argument based on this argument, which says that a long-standing practice has to prevail in absence of any rules, Your Lordship, guiding the post. The citation to কিমান আছিলে?
Yes.
So my respectful submission is that it is admitted fact as on date, Your Lordship, that these persons have been working since 2010. The department have been promoting people since 1993 to 2008. That is more than 25 years. Now, when it came to our chance, they said that we don't. They have not said that we don't, but they were not carrying out the things. So when it came up before this court, they say that no, we have no right to claim promotion to that post. We are not promoting any people. So my respectful submission is that Your Lordship will allow this petition and direct this respondent authorities that to follow the same principle and promote us the cadre of district malaria officer or to convene a DPC, Your Lordship. At best, that can be said, Your Lordship. Now, subject to what my friends say, I'll reply to that.
Lordship has asked one query regarding that draft service rule, ma'am. That I have brought on record. Yeah, that affidavit, Lordship will find in the affidavit file a response number 4, Director of Health Services. It was filed recently, my lord, on 8/2/2023. Page number 114. The running page number, my lord, 114. Yeah. Lordship will see, my lord, the name of the rule, draft rule, is District Malaria Officer Service Rules 2022. Now, my lord, this particular rule has been drafted and now it is lying with the government in the Health and Family Welfare Department. Here, Lordship will find page 115, cadre is, my lord, page 115, continuation, my lord, next page of the rules, draft rules. Cadre, my lord, District Malaria Officer. Next, my lord, 5, rule number 5, method of recruitment. 1, my lord, recruitment to the cadre of District Malaria Officer shall be made by direct recruitment / promotion from assistant entomologist subject to fulfillment of requisite qualification. So now, my lord, it has been incorporated in the draft service rule. Now, this rule is now under active consideration in the government, my lord. That Lordship will find in the affidavit filed by respondent number 1. There's a recent affidavit filed by respondent number 2. Running page number is 122. 122. Relevant part, my lord, it's a short affidavit. Lordship will find that page 124, para 3. My lord, after drafting of this, my lord, service rule, it was forwarded to the Personnel Department for their review. However, on 17 to 23, Personnel Department has made 8 numbers of observation relating to the draft so and so. So it is under process to rectify that
Thereafter, my lord, they will have to move the judicial department, including the finance department and legislative department. So what I submit before the honorable court is that, my lord, lordship may direct the health department to complete the entire procedure within a time frame. And, my lord, thereafter, my lord, to give the promotion to the petitioner if they fulfill the requisite qualification prescribed in these rules. Otherwise, it seems, my lord, they can fulfill. 5 years is their minimum time.
Supposing I give you a time frame, you can't complete at that time that the petitioners will keep on waiting.
My lord? No, there are two things, my lord.
We don't know how long you'll take.
That's why, my lord, if there is a mandamus of this honorable court, they will be, otherwise, my lord, they are bound by these orders of this honorable court. Lordship is not giving a order on merit. Lordship is saying that, my lord, since there is a draft service rule, you will have to follow it, complete the entire procedure. And thereafter, my lord, so do the necessary promotion.
May I just submit your
1
lordship?
minute, 1 minute.
And regarding, my lord, the merit in the writ petition, if
What about your affidavit? Page 104.
my lord. This is the director's affidavit. No, this is not, my lord, nothing to deny, my lord. These are on record, my lord. This is there in the record of the Director of Health Services. But lordship may now kindly have a look at the writ petition, my lord. The documents that have been relied upon by the writ petitioner. Because the government in the main writ petition, in the first affidavit in opposition filed by the government in the health department, they have stated that, my lord, whatever promotion was made in the earlier times, that now we cannot do that because the rules, draft rules has been, we have directed the Director of Health Services to draft the service rule and thereafter to furnish it to the government. Now they have done that part. The only thing is, my lord, to finalize the draft service rule and thereafter to make the payment, promotion, my lord. And, my lord, the promotional orders that has been referred by the present in the present writ petition, lordship will see all those promotions were not regular promotions. May I point out, my lord, page 49, 50 onwards. Page 50, Annex 11. It says, my lord, these are temporarily promoted to the post of district malaria officer under regulation 4D of Assam Public Service Commission Limitation and Functions Regulation 1951 for a period of 1 year. These are not regular promotions.
But then they have
One resorts to,
they have continued.
no, this is a separate issue, but this cannot be a mode of promotion, man. That's what I want to point out. Somebody has been, my lord, promoted under, my lord, regulation 4D or under regulation 3F. That, my lord, pointing out, my lord, that particular promotion order, the petitioner cannot claim that I should also be promoted to the next level post, which is not there in the service rules, in the similar mode, my lord. That he cannot claim, my lord. Had there been a service rule, of course he can make a claim that, my lord, I am eligible, I am waiting for so and so, so I should be promoted. Not a single order, my lord, to show. And, my lord, regarding promotion, creation of promotional avenues and all, my lord, these are, my lord, policy decisions, my lord. This honorable court, my lord, cannot step into the shoes of the legislators and, my lord, that can direct the government to create promotional avenues. Lordship can say that, my lord, these the persons are stagnating for a long period of time, so we must do something to create some avenue. Otherwise, the Assam Assured Career Progression Scheme is there, my lord. Pursuant to that scheme, my lord, in fact, I have a judgment of this honorable court to the effect of 7 judgments that, my lord, we'll have to either give them promotion or we'll have to give some financial benefit to them for working in a particular post for a long time.
Yes.
That, my lord, Assured Career Progression Scheme, my lord, in 10 years, my lord, if there is no promotion, they used to get 1 increment. And next, in the period of 24 years, my lord, if there is no promotion, then 1 more increment they used to get. Now that has been revised, now it's 3 increments, my lord. After the ROP 2017. The lordship is aware of this, my lordship is taking up bench 3 and all, my lord.
Heard Mr. Arsina. I can't hear you.
Your lordship, he has said that all my learned friend has just projected that all those promotions are not regular.
Whatever it is, whatever, without my mind, you listen to me, if there's any changes. you can-
And one more thing, your lordship, this draft service rules is something, it's a hypothetical story because from their
That will-
affidavit,
I'll take care of.
2023, they've sent. I filed my case in 19. They don't intend to do it. Only to save their skin, they're saying it, we have made it so that the court does not allow my writ petitions and they can continue with the same thing. What has happened?
There
And
is
your
no
lordship-
question of saving of skin, madam. There is not a contempt proceeding there.
And your lordship, 2023, what they say that
Promotion.
promotion is not a right. It's a policy decision that cannot be taken into consideration because promotion is a civil right. I have a right to be considered. You reject me, no issue.
Heard R. Sinan and Council. Also heard Mr. B. Gogoi, heard the Assistant Council. Health Department, isn't it,
Yes, your lordship.
for the response, for all the response. When was the advertisement? You have a date, any idea? Have you mentioned anything here?
No, your lordship, because that advertisement we didn't-
Pursuant to an advertisement for filling up the post of assistant entomologist in the Directorate of Health Services. The three writ petitioner hearing applied for the post. In as much as they had the requisite qualification of BSc with zoology. Draft on being successful in the recruitment process. The three writ petitions were appointed by different notifications, isn't it? Is it
Yes, your
not on-
lordship. Three
by-
appointment letters.
By different notifications, all dated 20 February 2010
Yes, your lordship.
as assistant entomologist against vacant post
Yes, sir.
under the Directorate of Health. Services. Since then, they have been serving as assistant entomologists till date without a single problem. According, being agreed for non-consideration of the case for promotion to the next higher post of district malaria officer,
Yes, your lordship.
they are before the court by way of the president. Praying for direction to the respondent to consider the case for promotion to the post of district malaria. Mr. R. Sina Nipala, learned counsel for petition, submits that there are no service rules governing the post of assistant entomologist and district malaria officer. And therefore, on the basis of a decision taken by the selection committee for promotion to the rank of district malaria officer on 29/5/1997, the candidates with having BSc with zoology and advanced entomology training, having at least 5 years regular service as assistant entomologist, were considered for promotion to the post
And promoted.
according to by notification dated 18th August 1992. For three persons, isn't it? Three assistant entomologists were promoted to the post of district malaria officer under regulation 4 within bracket small d of the Assam Public Service Commission within bracket limitation and function close bracket regulation 19 for a period of 1. By another notification dated. Where's the statute notification?
Page 56, Your Lordship.
Dated 12th March 2001. Two assistant entomologists were also promoted to the post of district malaria officer under regulation 40 of the on top it says the regulations of 1991 of the regulations of 19. The last promotion to the post of district malaria officer from the post of assistant entomologist was made by notification dated 25th July 2008 under Rule 40 of the regulation of 19. It is submitted that the present three written have completed about how many years?
13 years.
About 13 years. Yes, on date. And they also have the requisite qualification of BSc with zoology, along with advanced training.
Yes, Your Lordship. Your Lordship will just interrupt, Your Lordship. It will be almost more than 12 years. We have not completed 10 years, 13 years, it will be more than 12 years.
More than 12. Advanced training.
Yes, Your Lordship.
Along with advanced entomology training, which they completed in the year 2011, correct?
Yes, Your Lordship. I'll just check it. 11, 12. It will better to say 12, Your Lordship.
In the year 2012. As the post of assistant entomologist and the post of district malaria do not have any rules governing the service condition of the income. The respondents are therefore required to consider the case of in terms of the long-standing practice that has been followed by the department for promoting the assistant entomologist to the post of district malaria. To buttress this case, that in the absence of service, the department is the executive instruction and or decision taken administrative would operate in the field and appointment promotion can be made in accordance with such executive instruction administrative direction. He has referred to the case of Nagpur Investment Trust versus Yadav Rao Jagannath Kumbhari and others, reported in 1999, 1999. That much is sufficient for you, Mr. B. Gogoi, London Standing Council, Health Department. On the other hand, sufficient that the department has already formulated the draft service rule of the district malaria officer, named as the within inverted commas the district malaria officer service rule 2022, which was prepared by the Health and Family Welfare Department and has been sent to the Personnel B Department for review. However, on 17/2/2023, the Personnel Department has made 8 numbers of observations pertaining to the draft
One more submission in the affidavit filed by respondent number 1, 2, and 3. The first affidavit filed by the government. There's a-
1 minute, I'll come back.
No,
He therefore submit that as the department is in the process of rectifying the service, the department may be permitted to finalize the draft service of the district malaria office, and the petitioner may be considered for promotion under the set. So, yes, what you want?
well, one that regarding the judgment, my lord, that has been cited by the petitioner. There is that, my lord, in the absence of rules, my lord, if there is any executive instruction or some notification, the authorities must follow that. In para 5 of the affidavit that we have filed on behalf of the government, the earlier affidavit, my lord, there we have taken a categorical stand, my lord, that there is no such service rule, no executive order, no notification for promotion of assistant entomologist to the
submit
post of district
that
malaria.
there are no service rules governing the post of assistant entomologist and district malaria officer,
No service rule, no executive
and
order.
no standing instruction oblique notification from the state government for giving promotion
Of like,
to the post of. And therefore, comma, the reliance made by the general counsel to the petition in the case of Nagpur Improvement Trust, bracket Supra, is not applicable to the case. But I have heard the learned counsel. New part. A perusal of the records would indicate that the petitioners, on being successful in the recruitment process, were appointed as assistant entomologist by separate notification, all dated 20 February. Thereafter, the Director of Health Services, Assam, by a communication dated 28 to 2000, is it 12?
Which one, your lordship?
Page 39. Is it 17 or 12?
28 to
2017.
2017.
Wrote to the Joint Director of Health Services, within bracket malaria, Assam, come SPO NVBDB, NVBDCB, requesting for
The director has forwarded our representation to the secretary.
forwarding representation
Yes, your lordship.
made by the petitioner.
Yes.
And made a request to forward a list of assistant entomologists under the state, along with the vacancy position of district malaria officer. And SCRs for last 5 years. So, in reply, comma, the Joint Director of Health Service submitted the SCRs of 3 numbers of assistant entomologists within bracket petitioner as directed by the letter date 28 to 2017 on 22/6. Consequent thereto, the Director of Health Services wrote to the Secretary to the Government of Assam, Health and Family Welfare, by letter dated 5/8/2017 on the subject of annual confidential report of assistant entomologist, and the same reads as under. Just quote the whole thing, page 41. Page 2. If you can see properly, it would be better if you go to page 43. Page 2. drafted new para. The Deputy Secretary to the Government of Assam wrote back to the Joint Director to the Director of Health Services and the Joint Director of Health Services by communication dated 17th March 2018 with regard to promotion of assistant entomologist to District Malaria. And the same also features page 44. P2P. So, para. A perusal of the aforementioned communication dated 5/8/2017 and 17th March 2018 would clearly indicate that the department had taken initiative for considering the promotion of the petition to the post of district. However, drafts, nothing happened. No fruitful results came forward. Nepal. This court has also considered the minutes of the selection committee for promotion to the rank of district malaria officer from the category of assistant entomologist.
Your lordship, may I just I'm sorry to interrupt your lordship. Annexure 10 will also be relevant, page 49. The reason is that now the deputy secretary writes to the director as well as joint director that there is a meeting regarding promotion of the assistant entomologist to the post of district malaria officers.
That
Yes. That means that has been initiated. That's what I want to indicate here.
that other two will cover.
Yes, your lordship.
That has been replied in para 6 of the affidavit.
Yeah.
Pep-
Uh,
Para 6. Filed by government man.
which held on 29/5/1997, which indicate which projects that there are no service rule of the service order in matters relating to service conditions of various categories public posts under NMEB organization, including that of the district malaria. Stop. Accordingly, a decision was taken to fill up the post of vacant malaria district malaria officer, keeping the ratio of 2:3 by direct recruit and by promotion. Stop. The eligibility criteria provided in the selection committee in the minutes of the selection committee indicate that for direct recruit to APS, a candidate must be PhD with zoology as one of the subjects. And for promotion, a candidate must be PhD with zoology and advanced entomology training, having at least 5 years regular service as assistant entomologist. The case of the petitioner comes under the promotion quota and they have the qualification as laid down in the set minutes of the selection. But this court has also considered the act filed by the respond number. Who is this?
1, 2, and 3 man.
No, 2 secretary. Filed by the respond number 2. Public Secretary to the Government of Assam Health and Family Welfare within bracket 8 part on 1st April 2022, which indicates that the draft service rule, within inverted comma, district malaria officer service rule, 2022 has been prepared by the Health and the family will. Yes, and is in the process of finalizing. Stop. Para. After considering the entire fact of that, comma, district petition is disposed of, directing the respondent to finalize the draft service rule of
District malaria officer.
of within inverted comma, the district malaria officer within a period of 3 months from the date of the from the date of receipt of copy of the complaint. Thereafter, the case of the petitioner shall be considered for promotion under the para, the subpara. In the event the draft service rule is not finalized within the time frame given by this court, as indicated here above, comma, the case of the petitioners shall be considered for promotion to the post of district malaria officer by convening a special selection committee or a DPC, by convening a district departmental promotion committee for considering of the case for promotion to the post of district malaria officer within a period of 3 months from the date of expiry of the period for finalization of the. So
You know,
within,
that
within 3 months, if they cannot complete, then immediately after that 3 months, they will convene a TPC and consider.
That can be done within 1 month, your lordship. 3 months is a too long time. They can take a period of within 1 month to convene the DPC and promote us.
Within the period of 2 months.
Right.
With the appropriate
I
after
can read it.
the direct for TPC.
Obligation.
Your lordship, if they intend to, there is a direction of the Supreme Court. If they intend to finalize this draft rules, they can also promote me on the basis of this draft rules, your
That's what
lordship.
I've said. Once they finalize it,
Yes.
No, in fact, before finalizing, this is a draft rules, they say. So they can promote me on the basis of this
no,
draft
I'm
rules
not
also.
giving the direction. The draft is draft.
Obligation.
Deeply obliged, your lordship.